I may pardon, my lord. Item number 9, I pay for after lunch, my lord. I have some personal after lunch.
Amuri methodology.
I pay item number 9 may be taken up after lunch.
My lord,
Supplemental list.
I may pardon, my lord.
Item number 1.
Supplemental list item number 1.
May I please, Your Lordship? Your Lordship, item number 1, Your Lordship, I am alleging the non-compliance of the order dated 5/9/2024. Your Lordship, I filed an IA because inadvertently the name of the contemner was written as the previous officer, but in the meantime he has left the office. So I filed an amendment for the name of the present officer, Your Lordship.
In place of Sunil Kumar, it will be now Srimati Akta Kumari.
Yes, Your Lordship.
So we are allowing that interim application. No, this is formal thing. Thereafter, click on the IA number 161 of 2025. There is an application for amendment of the correction of the name of the container. Stop. The Land Council for the petitioner submits that when the content was filed, one Mr. Sunil Kumar was the General Manager Technical, NHI, and accordingly his name has been reflected as the contemner. However, in the meantime, the officer has been transferred and Srimati Akta Kumari has joined as General Manager Technical, NHI, and therefore petitioner may be permitted to correct the name of the contemner. Permission is granted. The corrected cause title of the contempt petition be filed, and thereafter the matter will be listed. You file it within a week. And
Your Lordship.
Next.
Item 2 is also similar, Your Lordship.
That IA is disposed of. Here also same prayer. Okay. You have here the consolidated cost title, I think.
Yes, Your Lordship.
But in the first one, you have not filed. Okay.
Your Lordship. I'll file within a week, Your Lordship.
Just a minute. Okay. It allowed for the Land Council petitioner has filed the consolidated cost title, which is taken on record. In the second item, which is the order according to you, which has been not complied with?
Lordship, that is order dated 18/9/2024.
2279. Come to the operative portion.
Your Lordship, it is in page 12, the operative portion, last paragraph. In view of the letter of the collector Burgard under Annexure 3 and the valuation report furnished by the executive engineer R&B Burgard, opposite point number 5 under Annexure 4, and after hearing the learned counsel for the Union of India, we direct the NHI authorities to take immediate steps for payment of compensation to the petitioner as per the valuation report under Annexure 4 within a period of 1 month from the date of production of a certified copy of this order, before taking any steps for vacating the premises. The NHI authorities shall also communicate the order to the concerned authorities for compliance.
When you produce the certified copy?
Yes, Your Lordship.
Achha, that is on
I have attached
presentation of the 3/10/2024. Notice for paragraph 3 order to produce. This contempt petition has been filed by petitioner Kamal Gupta, alias Kamal Kumar Gupta, for initiation of contempt proceeding against contemner Srimati Akhtar Kumari, General Manager Technical, NHAI, for violating the order dated 13/9/2024 passed by this court in WPC number 22798 of 2024, and to punish the contemner suitably as per law. The writ petition WPC number so and so was disposed of as per the order dated 18/9/2024, and in the operative portion it is stated as follows: quote, in view of the, that is page number 3 ru the next page for compliance. The Land Counsel for the petitioner submitted that the petitioner communicated the certified copy of the order to the contemner in pursuance to such order, and proof copy and the representation was also filed, and he has annexed the representation along with the postal receipts to the contempt petition. It is further stated by the Land Counsel for the petition that even though the period stipulated by this court has already expired, the contemner has not taken any steps for payment of compensation to the petition. Issue notice to the contemner, requisites for issuance of notice by speed post, proof of delivery we filed. During course of this, you filed that requisites.
Your Lordship.
Okay, might have been listed. Whatever, 3 weeks time we wrote down. 18th August 2025. 19th April, sorry, 19th April. Come to the next one.
Item 3.
My lord, order copy passed on 4 December, Annexion 1.
Come to the operative portion.
Order copy served with applications.
Madam, please come to the operative portion of the order, page number 2.
It is on the last para.
Yes, please read.
Taking into account the nature of relief sought for and dependency of the representation at the instance of the petitioner, this writ petition is disposed of directing the land acquisition officer and authorized officer NS16 for the Bhubaneswar, that is opposite part number 5, to consider the representation wide annexure 5 and dispose of the same in accordance with law within a period of 3 months from the date of production of the certified copy of this order by the petitioner, and communicate the result thereof to the petitioner within 2 weeks from taking the decision. It is made clear that this court has not expressed any opinion on the merits of the representation. Accordingly, Lordship, we have filed the
Take instruction about the status of representation. Welcome. This contempt petition has been filed by the petitioner Ratikant Samant Rai with a prayer for taking appropriate action against the contemner for deliberate and willful disobedience of the order dated 4/12/2024 passed by this court in WPC number 27498 of 2024, and to ensure compliance of the said order. The operative portion of the order dated 4/12/2024 reads as follows: for taking into account the paragraph says of merits of the representation. Land Counsel for the state of instruction about the status of representation. Put up this matter in the week commencing from 11th of August. Allah, in the meantime, the student of Jaha Kriyaga, se jani di chandi. Upon content petition ଜଣେଇଲେ ଯୋଉ ତାଙ୍କୁ ଅର୍ଡର କମ୍ୟୁନିକେଟ କଲେ ଲେଖିଛନ୍ତି
Yes, sir.
କୋଉ
Annexure,
paragraph?
Annexure
Acha,
2.
ଲେଖିଦିଅନ୍ତୁ। The averments has been taken in the content petition that the certified copy of the order along with an application to get decision on the representation was
10 December.
Delivered on.
Submitted on 10 December 2024, right?
Yes.
And the contemner was supposed to take a decision within a period of 3 months, that is 4/3/2025. But the petitioner has not received any communication regarding the result of decision taken on the representation. Let us further the operator. Yes, next.
Item 4.
4 minutes comply. The current counsel for the state has produced the written instruction received from so and so regarding the compliance of the order. Order is taken on record, content petition is disposed of.
Item 5.
At Lordship, I want the IA file for the disposal of the essay and along with IA
Second,
with the stipulated.
just a minute. Second, आइए किसी नौकरी item number 2 देखिए.
Amendment
आइटा अगुर अलग ही है ना को
165 টা ছিল।
IA second तारे श्रीमती अक्षर कुमारी
नहीं ये हमें
allow କରିବା ପୂର୍ବରୁ ସବୁ ଦେଇଛି। ନା order ଟା
नहीं allowed है ये. See आइटा
165 ହଁ।
165 ଟା already dispose of है इतना.
ସେଟା ଆର
खाली से consider ଆଉ लिखिବା ଦରକାର ନାହିଁ. ଖାଲି consolidate ଟା accept कर.
ସେଟା ଆର ବେଞ୍ଚ ରେ।
हाँ है ना ठीक ठीक. এটা enough but simplicity.
ଅନ୍ୟ ବେଞ୍ଚ ରେ
हाँ.
ଏଇ ବେଞ୍ଚ ରେ।
Yes.
When I file for the on the order dated.
Which item? Which item?
Item number 5 million.
हाँ.
File.
The writ petition was disposed of
Lordship. And
on 4/9/2024.
the honorable court directed to 4/9/24 order of 4% minor. So the Lord Counsel for the petitioner prayer to quash the notice under Annex 15 and 17. But during the course of the argument made as prayer is since SSAS of 23 is now subject before the tribunal court, the same may be direct to disclose one earliest. If the pleadings are completed and application is made in that respect, the court shall pass necessary order for expeditious disposal of the application.
कौन appropriate order को?
In this case, in 4/9/2024 to till date, already pleading are completed by both sides, but our Lawrence DRT has no discharge power.
Have you filed an application? We asked you to file an application for expeditious disposal, annexing the copy of the order which we passed on 4/9/24. Have you done it?
Already done.
Appropriate order कौन? जोटा कुहाई थिला paragraph 4 रे clearly लिखा है जी
Already
that
submitted.
if the pleadings are complete and an application is made in that respect, the court shall pass necessary. Where have you stated that in that IA which you have filed for appropriate order that you have submitted the application and along with the application you have annexed the copy of the order? Where is that?
Submit before the
ସବୁ ସେମିତି କହିଲେ ମୌଖିକ ଏଇଟା କଣ ମୁହଁରେ କଥା ହେବି କି ଅର୍ଡରଟା ପାସ୍ ହେଲା ଆମେ କେମିତି ଜାଣିବୁ ଆପଣ ଦେଇଛନ୍ତି? Why have you not, when you have filed an application for appropriate order, at least you should have mentioned all those things. ଏଇ ଦିନ ଏଇ ଅର୍ଡର ଅନୁଯାୟୀ ଏମିତି ଫାଇଲ କଲି ତା ଦେହରେ ଆଉ this is the copy of the application ସେଇଟାକୁ ଆନେକ୍ସ କଲେ ତାପରେ ହବ ହେଲା. So if you have already filed, move that application. If you have in spite of your moving the application, if no order is passed, file another interim application. You withdraw this.
Okay.
No? Current counsel.
But I am for the bank matter.
Has he filed any application?
Yes,
Or earlier?
as paragraph number 4 of the IA.
already.
Last three line, IN number 1765/2024, filed for advance hearing is disposed of as matter is already advanced, put upon 14/2/2025 for order on I and hearing of essay. In fact, my lord, both the parties, my lord, submitted their, my lord, written note of submission. Argument was over, my lord.
Okay.
But the order is not passed.
Sure. The IN number 11734 of 2025, the Land Council for the petitioner submitted that as per the order dated 4/9/2024, passed in WPC number 20782 of 2024, the petitioner moved an application before the Land and Debt Recovery Tribunal Cuttack in SN number 86 of 2023 for expeditious disposal of the said application, and the Land and Tribunal, after considering the petition, advanced the date of hearing and heard the matter, and the argument was closed on Kebe Royal.
On 14/2/2025, my lord.
Oh, acha. And argument was closed and the case was posted to 14/2/2025 for orders. For orders on
For hearing of essay and
hearing
IA.
of essay.
And on that date, my lord, the hearing was closed and both the parties filed their.
Acha, on 14/2 it was closed for orders on IN number 890 of 2023, and for hearing of the essay. And on 14/2/2025, the essay hearing was complete and the order was resolved.
Yes.
And till date, the order has not been pronounced.
Right.
That is your
Right.
contention. The status
What is the statutory period is there?
45 days na
60 days.
60 days. Get us the status.
se provision da ke kete कहले
Section 7. Okay.
Surface here to.
नहीं जो just I know that the problem. 17 वो 17 ना 17 ना को ये था 17 no. Any application made under so and so shall be dealt with by the debt recovery expedition as possible and disposed of within 60 days from the date of application. Provided so and so for time to time extend the period for regions to so and so. तापर दवासी नहीं होगा. अच्छा. The Land Council for the petitioner referred to subsection 5 of section 17 of the Surface Area Act 2002 and submitted that the time stipulated therein is already over, but in spite of that, the order has not been pronounced. Quote paragraph 17(5) reads as follows. Quote code. Let a report be called for from the register Debts Recovery Tribunal regarding the status of essay number 86 of 2023. The report should reach this court within a week. The Land and Register Judicial shall communicate the order to the register DRT. Matter will listed कर दूँ तो 12 तारीख से 12th of August 2025. Yes.
Item 6.
Item 6, notification of collector man opposite party number 2 wrongly Baleshwar ହେଇଛି ସେଟା collector Bhadra and district Bhadra.
कोटा बालेश्वर है जी.
Opposite party number 2.
वो अपना कॉस्ट हेले भूल कर देंगे. ऑर्डर किसी गंडगोल नहीं तो
order bullies.
हाँ ऑर्डर बोली जी कि खूब पारे रहो
Opposite number 2.
आप अपन ऑपोजिट पार्टी नंबर 2 आमे लिखिजु
आमे
अपन
तो
जहाँ
लिखिजु,
लिखिजु आमे
एड्रेस तो मुझे देन
we have not stated opposite party number 2 so and so so and so जहाँ जहाँ अपन करी थीबे ताले आमर कौन है ला there is nothing to be modified in that order.
She has filed with a prayer that to modify the cause title of the writ petition disposed of by mentioning Collector Bhadrak as opposite party number 2 instead of Collector Baleswar. My lords.
in her writ application, that means.
Yes,
She has mentioned it wrongly.
my lords. My lords.
We have not mentioned the name of the person.
He had mentioned as Collector Baleswar, it would be Bhadrak, my lords.
This IA number so and so is an application for modification, correction करते the correction of the cause title.
And consequent modification. नहीं हमें तो दरकार appointment दरकार.
Correction of the cause title of the writ petition 2319 that is WPC number 23894 of 2024. It is stated that inadvertently the opposite party number 2 has been mentioned as Collector Bhadrak.
Collector Baleswar लिखा है. It should be Collector Bhadrak.
अच्छा. Collector Baleswar. Instead, it should be Collector Bhadrak. And they may be corrected. Stop. In the Land Council for the state has no objection. In the post title of WPC number 23894 of 2024, the opposite party number 2 shall be read as Collector Bhadrak District Bhadrak in place of Collector Baleswar District Baleswar. IA is disposed of.
Yes, and also in the order, the Lordship has categorically stated opposite party number 2.
Now opposite party number
one.
That has.
Yes, next.
Wait.
Item 7.
न्यायालय return of certificate copy order Annex 3 wrongly typed with 1 day.
Return of certified copy.
Order Annex 3. Copy of order dated 17/10/2023.
No, why certified copy will be given to you?
Refer for the filing for the civil court filing. Certificate copy refer for the civil court the filing.
You get another certified copy.
It is to substitute by certified copy again, and
there is an interim application filed for returning the certified copy under Annexure 1. We are not inclined to pass such order. Accordingly, IA is disposed of. Yes.
Item 8.
Made please, my lords. Here the Lordship had called for the whereabouts as to the status of the appellants on the last occasion.
must have come as completed.
I may be excused, my lord. But before proceeding that, I am written note on 248/98 and 248/98, Lordship last occasion reserved the judgment. Filing the written note may be date of 1990.
अच्छा तो रिजर्व है तेरा फाइल करछन on behalf of
Yes, state.
Please give.
oh so जो
Dita to reserve ଅଛି. ଏଇଟା କୁହନ୍ତୁ ମ ସେଟା ତ ହେଲା ରଖିଲି କଣ ହେଲା କଣ instruction ଆଇଲେ It appears that there are 7 appellants in this appeal, out of which appellant number 6 is laid, and as per order this court has passed regarding abatement of the appeal so far as appellant number 6 is concerned. When you made a query regarding the well-being of the other appellant, appellant number 125 and 7 as well as their whereabouts, and counsel for the state should some time to obtain instruction in that respect to the IAC swan. Okay, not applicable.
ಇನ್ನೊಂದು theory ಇತ್ತು ಅಲ್ಲಿ
Well-being of these swans, no. The visiting the fund, all they are available in the. Acha, look on. As for the order dated 24/7/2025, the Land Council for the state has obtained the written instruction dated 29/7/2025 from IIC Begunia Police Station, which reads as follows: Pura Court Zone. The written instruction is taken on record. Yes, sir.
ଏମାନେ ସବୁ ବେଲରେ ଅଛନ୍ତି ତ?
Only appellant number 6 had died.
That is there. That is the order.
Dita number or Dita volume.
ଆମ ପାଖରେ ତ ଆଜ୍ଞା ଗୋଟେ ହିଁ ଭଲ୍ୟୁମ୍ ଅଛି।
ନାଇଁ ନା ଦିଟା ଭଲ୍ୟୁମ୍ କଣ
ଗୋଟେ ଭଲ୍ୟୁମ୍ ଆଜ୍ଞା ଆମ ପାଖରେ ଅଛି।
ବୁକ୍ ପର୍ଯ୍ୟନ୍ତ ଅଛି, ଗୋଟେ ଫାର୍ଷ୍ଟ ଭଲ୍ୟୁମ୍ରେ ବୁକ୍ କରିଦିଅ। এটা up to judgment ଇଏ ଅଛି। accused statement
ପର୍ଯ୍ୟନ୍ତ ଅଛି।
କେବଳ accused statement। Judgment and accused statement is in one, volume 1. And volume 2 is about statements. No.
There will be accused statement. Second टा मुझे complete होची। नहीं, second judgment पर नहीं।
Second judgment.
कितने जन accused लगी?
आगे total 7 accused persons।
तो पूरा लिखा है।
कौन statement
कितने बड़ा?
जने accused ପାଇଁ कितने question
ଗୋଟେ ଭଲ୍ୟୁମ୍ ଅଛି। ସେଟା କଣ ଅଛି?
CRL number 2 तो এটা No, there were as many as 36 accused persons.
In the learned code book,
that is what we see.
Oh, I'm sorry, Milad. There were all total 57, 58 people stood trial.
Oh,
Out of
58 people stood trial.
that is how the accused statements have gone in lengths.
এটা ଅଛି 36 এটা ଅଛି 36 ଟା ଆগে କେତେ ଅଛି
Total 64, including these appellants. I'm sorry, Milad, I was not able to understand.
এটা 37 ଅଛି ଏଇଟାରେ ଯୋଉଟାକି ଅଛି up to 36 ପର୍ଯ୍ୟନ୍ତ accused statement ଏଇଠି ଆରଟାରେ 37 ରୁ 64 ପର୍ଯ୍ୟନ୍ତ ଅଛି ତା ଛଡା ଯୋଉ deposition copies ଗୁଡାକ
Some forwarding report, examination report, spot. So, you have not received the volume 2?
No, Milad, we have one volume that is there with us.
So that is all statement and judgment.
No, what is you have got volume 2 or volume 1?
I have the judgment and depositions as well as the forwarding. Yes, Milad.
That is the
Deposition.
So it is volume 2.
Again.
Judgment is there.
Again, judgment.
Not consulted.
I don't. Judgment is there, Milad.
Judgment is there.
Again.
ତମ ଉପରେ କିଛି ଲେଖା ହେଇନି ଭଲ୍ୟୁମ 1 କି 2?
ନାଇଁ ଆଜ୍ଞା ସେଟା ମାନେ ବହୁତ ଆଗରୁ ହେଇଥିଲା ମୁଁ ସେଥିପାଇଁ ତାର ପେଜଟା ବି ଟାଇପ କରିଦେଇଛି।
ଆଚ୍ଛା
Unless they might have
সেইটার
given
কিন্তু
consolidated,
লেখাই আছে যে আমরা
but judgment is there, the quotations are there.
appeal memo kind?
appeal memo is there, my lords.
appeal memo
এইটার মোরটারে হচ্ছে
2 to 11 7 জন appellant.
again. Appellant number 6 has died. That is, there's a judicial order, my lords. That is order number 27, 18, 12, 22.
So judgment is in which paper book? अच्छा, bar 39 है, ठीक है. One 47, 148,
Again.
302 by 149. ଏଥିରେ ସେମାନଙ୍କୁ conviction ହେଇଛି.
Again. All total, my lord, 64 of them stood trial. And conviction has been sustained for these 7 persons, which is under sections 147, 148, 302 with 149 IPC. And these appellants have also been further for offences under section. No, my lords, that is it. 147, 148, 302 by 149.
Come to the judgment paragraph number 21.
Again. Again. My lords, may I please it?
Yes,
Paragraph
just
21.
a minute. 21.
And keeping the aforesaid principles of law in view, I now proceed to discuss how far the prosecution has been able to fasten the other accused persons so far as the offence under section 302 and with 149 of the Indian Penal Code is concerned. It may be noted that it is in the evidence of 1, 6 and 15 that at the time of incident the accused Vidyadhar Sahu climbed.
Just a minute.
Aଜ୍ଞା.
ଆପଣଙ୍କର appellant number ଗୁଡାକ ଏଇଠି କହିଦିଅନ୍ତୁ.
Aଜ୍ଞା.
ଯୋଉଟା ସବୁ conviction is ସେଟା ଲେଖିଛନ୍ତି ତ ସେଥିପାଇଁ. Vidyadhar is-
Prepare that kind of table if you
ଆଚ୍ଛା, ଓକେ ଅଛି, ପଢନ୍ତୁ.
Dinobandhu is appellant number 1.
ନାଇଁ ଏଇଟା ପଢନ୍ତୁ. Accused
Aଜ୍ଞା.
Vidyadhar Sahu.
Vidyadhar Sahu.
Vidyadhar Sahu is not the appellant.
No, my lords.
Yeah.
He has been acquitted.
Okay. Read it out.
Climbed to the roof of Pandari Naik, made a peep hole by removing the thatch of the house and detecting Jadumani, who is the deceased, my lords,
Okay.
inside the house of Pandari.
Pandari is not an accused.
No, my lords,
he's a
Pandari is
PW3.
PW3. He's a witness, not an accused.
Okay. PW.
So Jadumani had taken shelter in the house of Pandit.
Again. Made a peephole, called the other accused persons. But from the cross-examination of these witnesses, it appears that this fact was not stated by them before the IO. Therefore, the evidence against accused Vidyadhar Sahu at this stage cannot be accepted to be reliable.
Yes, next.
At 22 minutes.
Hmm.
Though PW4 Budhi Dei has deposed that on the date of occurrence, accused Kaibalya Dehuri gave a Katuri blow to the right side scapula
Kaibalya is also acquitted.
again.
Hmm.
Of her husband, causing bleeding injuries, and when she went to rescue of her husband, accused Bhagwan Behra is also not an accused appellant here.
Bhagwan Behra must have been acquitted.
Again, dealt a lathi blow on her head, and accused Billua dealt another lathi blow on the right side wrist and backside of the palm of her hand. Her evidence to this effect does not find corroboration from the evidence of her husband examined as PW11. PW11 is Chaitanya Naik. According to PW11, on the date of this occurrence, while he was going to the house of Pandari Naik to take shelter, on the way, accused Kaibalya Dehuri dealt a blow by means of a katti on his right foot, and accused Tiki Naik dealt another blow.
Kaibalya Dehuri. Kaibalya is not an
accused.
Appellant and right foot. Tapre Tiki Naik.
Tiki Naik.
Tiki Pradhan achi. Tiki Naik. Tiki Naik acha.
Again. Who is appellant number 3?
No,
Tiki Naik is another. Tiki Naik is not there, different person. Dealt another blow by means of a farsa on his right forearm, and accused Tikina Pradhan, who is appellant number 3, dealt a tangia blow on his right hand shoulder. In view of such discrepancy in the testimonies of this witness, I am inclined to say that accused Kaibalya Dehuri, Tiki Naik and Tikina Pradhan cannot be said to have assaulted PW11. Para 24. Their son Basanta has been examined as PW18. According to him, on the date of occurrence, he was assaulted by Nabha Naik, Sarata Naik, Bilwa Naik by Lathi, and accused.
Emana bhitor ke appellant nahanti?
Na.
Okay.
And accused Kailash dealt a Katuri blow to his right leg. PW9, who examined the injured persons, has stated that he noticed these injuries, including one incised wound on the right shoulder. If Katuri blow was given by accused Kailash on the right leg of PW18, he must have sustained an incised wound there. But the evidence of the doctor shows the presence of an incised wound on the right shoulder, and this PW18 is unable to say how this incised wound on the shoulder was caused. Therefore, his evidence implicating accused Nabha Naik, Sarat Naik and Bilwa cannot be accepted. PW19 Kumar Naik has deposed that on the date of occurrence, he was assaulted by Niranjan Naik by means of lathi, causing bleeding injury on his left ear. According to him, his wife and daughter were present when this accused assaulted him, but none of them has been examined in the case to support the testimony of PW19 to this effect. Moreover, though it is stated that he was assaulted inside his house, he has contradicted himself by saying in his cross-examination on recall that he was not assaulted inside his house. PW7 Kulamani Naik has sustained 2 injuries as per Exhibit 21. According to him, Jogi Behra dealt a lathi blow on the left forearm and Bhagia Behra gave 2 plucking blows on the left scapula. From the evidence of the doctor examined as PW9, it appears that this witness sustained only 2 injuries and there was only 1 injury on the left scapula. The doctor had examined one Kaliko Naik and Lochan Behra, but they have not been examined in this case. Doctor has proved the injury reports issued by him as Exhibit 16 to 22 and has stated that some of the injuries are superficial in nature and could be self-inflicted. Thus, the evidence of these witnesses regarding individual assault on them cannot be accepted to come to a definite conclusion that at the time of this incident, any of the accused persons except 7 referred to above shared the common intention in prosecution of common object of the unlawful assembly. Thus, on careful consideration of the oral evidence adduced on behalf of the prosecution, I am of the firm conviction that prosecution has not been able to establish charge under section 302 read with 149 IPC against accused persons except Dinabandhu Dehuri, Rajkishore Dehuri, Gauranga Pradhan, Tikina Pradhan, Sridhara Behera, Madhav Behera, who has died, Milord, and Gagan Pradhan.
এটা কেমতি আইলে
সেইটা
এটা পুরো পূর্বରୁ ডিসকাশন বলে
ସେଇଟା
ପୂର୍ବ ପାରାଗ୍ରାଫ
ଏଇଠୁ ଆସୁଛି ଆଜ୍ଞା।
ଯେତିକି ଆମେ ପଢିଲୁ ତା ଭିତରେ କିଛି ନାହିଁ
ନାଇଁ, ସିଏ ଡିସ୍କ୍ରିପେନ୍ସି ଟାକୁ ନୋଟ କରୁଛନ୍ତି।
ସେଟା that is where we are coming to that how he
para 14 of the judgment।
ହଁ ସେ ଗୋଟେ ଥିବ ତା ପୂର୍ବ
ଆଜ୍ଞା, thus from the evidence of PW 1, 6 and 15 para 14, may I place it, my lords?
ହଁ ସେଇଠି ପଢନ୍ତୁ
ଆଜ୍ଞା, para 14, thus from the evidence of PW 1, 6 and 15 it is seen that on the date of occurrence accused Dinabandhu, appellant number 1,
just a minute, appellant number 1,
Shri Rajkishore Dehuri, he is dead, appellant number 6.
so dead.
Gagan Pradhan is appellant number 5. Tikina Pradhan is appellant number 3. Gauranga Pradhan is appellant number 4. Sridhar Behera is appellant number 2. Madhav Behera is appellant number 7. Being armed with deadly weapons like konta, farsa, koturi, tangia and lathi, assaulted the deceased over the land of Padmanabha Sahu, and in consequence of that, Jadumani Behera died at the spot. Evidence of these witnesses regarding implication of Niranjan Naik as stated by PW1 and Tikina Naik as stated by PW15 being inconsistent, they were entitled to the benefit of doubt. It is contended by the learned defense counsel that the evidence of these witnesses shows that all these accused persons were armed with sharp cutting weapons, but the injury number 9 as revealed from the evidence of PW8 is a lacerated injury, but none of the witness has stated how this lacerated injury was caused.
मेरा लाठी अछि पूरा तादेरे ऊपर जो
ऊपर है क्या लाठी?
लाठी जो ये contention के अंदर है इसमें all these sharp cutting weapon में तो konta, farsa, koturi, tangia, that may be different, but what about lathi? Yes, read it out.
Which as per the postmortem report is the cause of death of the deceased. In the above background, it is urged that the charge under 302 read with section 149 Indian Penal Code has not been established by the prosecution against these accused persons. But as discussed above, PW 6 and 15 have categorically stated that some of the accused persons were also armed with lathi, and in such circumstance, the possibility that injury number 9 must have been caused by the same lathi cannot be ruled out. In addition to that, doctor in para 7 of the evidence has stated that IO had also sent 1 Koturi and 1 Gupti for his opinion, and after examining the same as per exhibit 15, he replied that injury number 1, 6 and 9 could be caused by Koturi, and rest external injuries could be caused by a knife. And there is nothing in the evidence of the doctor to suggest that the opinion given by him as per exhibit 15 is not correct. In the above background, I do not find force in the contention of the defense counsel that prosecution had not been able to establish how injury number 9 was possible, which is prime cause of the death of the deceased. Para 15 minutes. it is next contended by the learned defense counsel that injury number 9 is undoubtedly due to an accidental fall as admitted by the complainant himself in para 7 of the cross-examination of PW 15. It is seen that the complainant has admitted that while running, deceased Jadumani fell down on the land of Padmanabha South and he was not assaulted by any one of the accused persons before he fell down. In the premises, it is suggested to him that the deceased died due to fall on the land of Padmanabha Sahu and no one had assaulted the deceased there. Such a suggestion appears to be without any basis. If one of the above accused persons had assaulted the deceased over the land of Padmanabha Sahu, it is not known how the other 8 external injuries were noticed on the body of the deceased during postmortem examination, and all these injuries are antemortem in nature. Thus, from the discussion above, it is seen that the evidence of PWs 1, 6 and 15 to the effect that on the date of occurrence, accused Raja Kishore Dehuri, who is appellant number 6, Millards, Dinabandhu is appellant number 1, Tikina is appellant number 3.
Just a minute. 6 is dead.
Again.
Dinabandhu?
No, Dinabandhu is alive. Raj Kishore
Dinabandhu number ta
A1.
Tikina
is A3. Gauranga is A4. Sridhar is A2. Madhav is A7. And Gagan is A5. Being armed with lathi, farsa, konta and bhali, etc., murdered the deceased Jadumani over the land of Padmanabha South. Is clear and convincing, and I do not find any reason to discard their evidence on this score. On the other hand, the evidence of these 3 witnesses also finds support from the eyewitnesses referred to above.
Okay. So 1, 6, 15 are the 3 eyewitnesses.
Yes.
Okay. Next, read out the next paragraph.
PW3 Pandari Naik has deposed that on the date of occurrence, Jadumani, who is the deceased Millards, his brother Madhu and their family members rushed to his house to take shelter, and while they were inside his house by bolting the door from inside, accused Raja, who is appellant number 6, who is no more Millards, armed with a farsa, Dinabandhu, that is A1, with a kotari, Gagan is appellant number 5 with a kathi, Tikina, who is appellant number 3 with a tangia, Sridhar, who is appellant number 2, and Madhav, who is appellant number 7 with farsa, and Gauranga, who is appellant number 4 with a koturi, chased Jadumani. And seeing the violent mood of the accused persons, he fled away to the backside of his house. In his cross-examination, it is stated that he cannot explain as to why he did not go to the police station after he escaped from his house. Different persons act different in different situations. Sorry, Millards. Different persons act differently. In different situations, and simply because after escaping from the house he did not go to the police station to report the matter is not a ground to discard his evidence on this score. PW10 Basanti Dei is the daughter of the deceased. According to her, on the date of occurrence, she had been to Contabad in connection with agricultural labor, and while in Contabad, she received information that the accused persons had mounted an attack on their house, and getting that information, when she rushed to the spot, she found her house to have been razed to the ground and also found his father Jadumani chased by above 7 persons being armed with lathi, katti, koturi, farsa, etc. Thus, the evidence of 1, 6 and 15 also finds support from the evidence of the aforesaid witness so far as chasing of the deceased by these accused persons is concerned. It is next contended by the learned defense counsel that the prosecution has sought to establish the charge by examining not only partisan witnesses but also their close relations of the deceased. It needs no mention that in a fact-ridden society where an occurrence takes place in a village involving rival factions, it is but inevitable that the evidence would be of partisan nature. And in such situation, to reject the entire evidence on the sole ground that it is partisan amounts to shutting one's eyes to the realities of the rural life in our country. In this context, reference may be made to the decision reported in AIR 1978 SC 1647. In this reported case, it has been observed by their lordships that large number of accused would go unpunished if such an easy course is charted. It is further observed that simultaneously it is to be borne in mind that in such a situation, the easy tendency to involve as many persons of the opposite faction is as possible by merely naming them as having been seen in the melee is a tendency which is more often discernible and is to be eschewed, and therefore the evidence has to be examined with utmost care and caution. Thus, it is seen that the evidence of these witnesses cannot be thrown out overboard merely because they are close relations and partisan witnesses.
These three witnesses are related to each other.
Again.
And also to the deceased.
No. These three witnesses.
One is a co-village.
Two of them are related, one is a
15 are
No, they are related to the deceased.
Father and daughter.
And
And related to the deceased.
Just a minute. PW1 ro na ta koile?
PW1 is, my lords,
PW1.
Juni Behra.
Juni.
Okay, Juni Behra.
She is daughter of PW15.
Juni Behra is the daughter of PW.
Niece of PW15, daughter of the deceased.
Acha, daughter of deceased.
Aye.
Acha, तापरे बाकी आउ दीटा परा?
6 हो
I would have 6, PW6.
PW6 का नाम कोई?
Ramesh Naik.
The co-villager examined 4 days after.
Ramesh
Naik.
Ramesh Naik is
PW6.
Ramesh Naik is late Sagar Naik.
independent witness.
See, independent but
Independent. Right.
Independent.
6 is independent.
Jane,
ଆଉ 15
I would have 15 Madhu Behra, who is the informant, who is the brother of the deceased.
15.
15. Madhu
Madhu Behra.
son of Kulamani Behra is the brother of the deceased.
Aye. ये तीनों
This is Sadhu Behra is my brother.
Aye.
PW1 is the daughter of the PW15.
Niece of the deceased and daughter of PW.
Is
The
the
daughter of the PW15, not daughter of the
Daughter of deceased, no.
No. Niece of the deceased and
PW15 is the informant.
Just a minute. Daughter of PW15 and
Niece of the deceased.
niece of deceased.
PW10 ଟା ହଉଛି ତା ନିଜ ଝିଅ।
PW9 or 10 କିଛି କହିନି।
ନା ସେ ତ କହିଲା ଆଉ ସେ ଖାଲି 3ଟା ଆଇ ୱିଟନେସ୍ ଆଉ।
ये तीनोटी आई विटनेस को ऊपर रिलाई कराएगी तो
by the way, Dr. K. PW.
Dr. PW.
PM Doctor.
8.
भुवनेश्वर फंड।
प्रथम पढ़े ग्रुप छाड़ते से पढ़ो।
My lords, internal page 19 of the judgment.
Thus it is seen.
7 lines from.
Hmm.
Thus it is seen that the evidence of these witnesses cannot be thrown out overboard merely because they are close relations and partisan witnesses. On the other hand, relying on a decision reported in 1996 Criminal Law Journal 852, it is submitted by the learned public prosecutor that ordinarily in a case of murder, even close relations of the deceased would not falsely implicate any innocent person.
Supreme Court decision ना ये decision
Criminal Law Journal
देखी ना दी
नहीं
এটা এই বলটা টিপিলো 19 এটা
1896.
So,
Journal 852.
Criminal Law Journal,
852.
852. Mother's Lecture Patina.
That ordinarily in a case of murder, even close relations of the deceased would not falsely implicate any innocent person, allowing real assailants to go scot-free. In this reported case, it has been observed that a witness cannot be merely disbelieved on the ground that he is related to the deceased. However, evidence of such related witnesses will have to be assessed carefully, and after careful assessment
Of
evidence, if it is found to be acceptable, the court will be justified in acting on the evidence of such witnesses. It has been held that where in a murder case only eyewitnesses to the incident was the son and brother of the deceased persons, he could not be called as an interested witnesses, though he may be related to the deceased, as he had no reason to save the real culprit of his father and brother and involve in place of real culprit some other accused falsely in case. In view of the principles laid down in the above reported cases, keeping in view the unassailed testimonies of PW 1, 6 and 15 which find support from other witnesses referred to above, I have no other option save to conclude that on the date of occurrence, accused Rajkishore Dehuri, appellant number 6,
Dead.
again, Dinobandhu, appellant number 1, Gagan is appellant number 5, Sridhar is appellant number 2, Madhav is appellant number 7, Tikkon Pradhan is appellant number 3, and Gauranga is appellant number 4. Forming an unlawful assembly armed with deadly weapons murdered the deceased Jadumani in prosecution of their common object. Another intrinsic circumstance against these 7 accused persons is that their names find place as principal assailants in the FIR, lodged at the spot within 1 hour from the occurrence, which rules out the possibility.
FIR
was given at PW 15. Which rules out the possibilities of any false implication of these accused persons at that stage. Now I proceed to discuss whether the other accused persons facing trial in the case which your lordship has already gone.
No, you read it from paragraph 21. So read this paragraph.
Now I proceed to discuss whether the other accused persons facing trial in this case can be made liable for the offense under section 302 head with 149 IPC. It may be noted that mere presence of an accused at the place of occurrence would not make him constructively liable in the absence of any positive evidence of his having shared any common object. If it is established that he shared these common objects of others, being a member of an unlawful assembly, he can be fastened with the liability under section 149 IPC. It cannot be lost sight of the fact that in a faction-ridden society where an occurrence takes place in a village involving rival factions, the easy tendency to involve as many persons of the opposite faction as possible by merely naming them as having been seen in the melee is a common tendency, and in the above background, their lordships of the Apex Code in the decision reported in AIR 1978 Supreme Court 1647 have observed that the evidence in such eventuality has to be examined with utmost care and caution.
Page number 1647.
Criminal revision judgment of the Karnataka single bench.
Criminal law judges.
No, principle is very settled. That's the legal Supreme Court. So, virtually your case now rests upon the acceptance of otherwise of this evidence of three witnesses. 1, 6, 15, and of course the doctor.
PW.
So you are not disputing about the homicidal death.
No, my lord.
Now, so let us read then the FIR and then go to the evidence of the FIR. कितने number page है?
FR page 40.
वो paper उतरा. FIR अच्छा page 40.
वो पेपर बुक लेता हूँ। हाँ 40 तो 40. Let's me please.
Just. हाँ पढ़ो.
ମୁଁ ଶ୍ରୀ ମଧୁ ବେହେରା ପିତା କୁଳମଣି ବେହେରା
15 PW15
ଆଜ୍ଞା PW15 ପିତା କୁଳମଣି ବେହେରା
ଆପଣଙ୍କର ନାଁ ଆସିଲା ବେଳକୁ ରହି ଯାଉଥିବେ ଟିକେ
ଆଜ୍ଞା
କହିଦେବେ ସେଠି.
ଆଜ୍ଞା ରେଲିଭେଣ୍ଟ ଆଜି ତାରିଖ 24/8/1994 ଲିଖ ଦିନ ଘଟିକା 12:30 ସମୟରେ ମୋର ଗ୍ରାମର ଉପସ୍ଥିତ ଥିବା ପୋଲିସ ଅଫିସରଙ୍କୁ ଏହି ମୌଖିକ ଏତଲା ଦେଉଅଛି ଯେ ଗତ 22/8/1994 ରାତି 8ଟା
ଘଟଣା ହେଇଥିଲା 22 ତାରିଖ ଦିନ.
ଆଜ୍ଞା
ଆଚ୍ଛା
ସେଇ ଦିନ ଯୋଉ ଦିନ ଏତଲା ସେଇ ଦିନ ଘଟଣା
it is with reference to another context.
22 ତାରିଖ ଦିନ ଗୋଟେ ଭିଡିଓ ଶୋ ସେଥିରେ ଗୋଟେ କମେଣ୍ଟ ପାସ୍ ହେଇଥିଲା ଯୋଉଥିପାଇଁ ଗୋଟେ ଭିଲେଜ ମିଟିଂ ବସିଥିଲା. ମିଟିଂ ପରେ ଗଣ୍ଡଗୋଳ.
ଆଚ୍ଛା ପଢନ୍ତୁ.
ରାତି 8ଟା ସମୟରେ ଆମ ଦୁଆର ପାଖରେ ଥିବା ମଣ୍ଡପରେ ଆମ ଗାଁ ବଡ଼ ସାହିର ପିଲାମାନେ ଭିଡିଓ କରୁଥିଲେ. ଅନ୍ୟ ପିଲାଙ୍କ ସହିତ ମୋ ଝିଆରୀ କୁମାରୀ ବାସନ୍ତୀ ବେହେରା he is a witness Millers. ବାସନ୍ତୀ is PW10.
ହଁ ସେଇଟା
ସେ ପୂର୍ବ ଘଟଣା.
ଆଜ୍ଞା ପୂର୍ବ ଘଟଣା. ବାସନ୍ତୀ ବେହେରା ପିତା ଯଦୁମଣି ବେହେରା who is the deceased ଭିଡିଓ ଦେଖୁଥିଲା. ଏହି ସମୟରେ ବଡ଼ ସାହିର ଦୀନବନ୍ଧୁ ଦେହୁରୀ appellant number 1 ପିତା ପଦ୍ମନାଭ ଦେହୁରୀ ମୋର ଝିଆରୀକୁ କମେଣ୍ଟ ପାସ୍ କଲା ଓ କହିଲା मैं तुमको प्यार करूंगा I love you. एकथा शुणी मो झियारी सेठारु उठी आसी मोर सान भाई मथुरा को कहिला. मथुरा दीनार बापा को ए विषय रे जणाइला एवं तुरंत
मथुरा एग्जामिन ହେଇଛି.
मथुरा
ହେଇନି.
मथुरा PW13
ହଁ ପଢନ୍ତୁ.
ଏବଂ ତୁରନ୍ତ ସମାଧାନ କରିବା 23/8/94 ରିଖ ସନ୍ଧ୍ୟାରେ ଏ ବିଷୟରେ ଆମ ସାହିରେ ସଭା ହେଲା. ସଭାକୁ ମୋ ସାନ ଭାଇ ମଥୁରା ଝିଆରୀ ବାସନ୍ତୀ ଏବଂ ଆମ ସାହିର ସୁର ଦେହୁରୀ ଗଲେ. ସଭାରେ ଦୀନା ଦେହୁରୀ who is appellant number 1 ମୋ ଝିଆରୀକୁ କହିଲା ଯେ ତୁ ସତ୍ କଥା କହିବୁ ନହେଲେ ଠିଆ ଚିରି ଦେବି. ମୋର ସାନ ଭାଇ ଏହାର ପ୍ରତିବାଦ କରିବାରୁ ଦୀନା ତାକୁ ପଛପଟୁ କୁଣ୍ଢେଇ ଧରିଲା. ଏହାପରେ ମୋର ସାନ ଭାଇ ଏବଂ ଝିଆରୀ ଓ ସୁର ଦେହୁରୀ
ସେଠାରୁ ପଳାଇ ଆସିଲେ। ଏମାନଙ୍କ ଆସିବା ପରେ ପରେ ବଡ଼ ସାହିର ଲୋକମାନେ ହୋହାଲ୍ଲା ହେଲେ ଓ ଟେକା ପଥର ଆମ ସାହି ଆଡ଼କୁ ପକାଇଲେ। ତାପରେ ଆମେ ସମସ୍ତେ ନିଜ ନିଜ ଘରେ ରହିଲୁ। ରାତିରେ ଆଉ କୌଣସି ଅସୁବିଧା ହୋଇ ହେଲା ନାହିଁ। ସେହି ରାତିରେ ଆମର ବିରୋଧୀ ଆଦିବାସୀ ସାହି, ତଣ୍ଡାଳ ଶବର ସାହି, ସବର୍ଣ୍ଣ ସାହି, ନୂଆ ସାହି ଓ କାଚେରା ଗ୍ରାମବାସୀ ମାନେ ମିଟିଂ କଲେ। ଯାହାକୁ ମୁଁ ଆଜି ସକାଳେ ବାହାରୁ ଖବର ପାଇଲି। ଆଜି ସକାଳ 8ଟା ସମୟରେ 400 ସାହି ଲୋକ ମାନେ ଯଥା ତଣ୍ଡାଳ ଗ୍ରାମର ପ୍ରଫୁଲ୍ଲ ସାମନ୍ତ, ଚିନ୍ତାମଣି ସାହୁ, ବନମାଳୀ ସାହୁ, ତ୍ରିଲୋକ୍ୟ ସୁବୁଦ୍ଧି, ଏଇଟା ଆଜ୍ଞା ମୁଁ ପଢି ପାରୁନି, କଣ ରାଜା ମହାନ୍ତି, ଗଗନ ପଣ୍ଡା,
ବିଷୟବସ୍ତୁ ଆଇଲା ବେଳକୁ ସେଇଠି କରାଯାଉଛି। ହଁ, ଏଗୁଡ଼ା ଏମାନେ ମିଟିଂ କଲେ ବୋଧେ।
ଆଜ୍ଞା,
ଆହୁରି 70-80 ଲୋକ ଏ ନୂଆ ସାହିର
ଠେଙ୍ଗାବାଡ଼ି, ତା ନେକ୍ସଟ ପେଜ ପଳାము।
ଠେଙ୍ଗାବାଡ଼ି କଟୁରୀ ଫାର୍ସା କଟୁରୀ ଧରି ଆମ 18 ଘର ଉପରେ ଆକ୍ରମଣ କଲେ। ଏହା ଦେଖି ମୋର ସାନ ଭାଇ ମଥୁରା ବେହେରା ବିଲରେ କାମ କରୁଥିବା ବେଳେ ଥାନାକୁ ଖବର ଦେବା ପାଇଁ ଖସି ଆସିଲା। ସେହି ଲୋକେ ମାନେ ମୋର ତଥା ଆମ ବସ୍ତିର ଘର ଭଙ୍ଗାରୁଜା କଲେ। ସମସ୍ତଙ୍କ ଘରୁ ପ୍ରାୟ ଟଙ୍କା, ସୁନା, କଂସା ବାସନ ଆଦ୍ୟ ପାତ୍ର ନେଇଗଲେ। ଫାର୍ସା କଟୁରୀ ବାଡ଼ିରେ ନିର୍ମଳ ଭାବରେ ଆଣିଲେ ଏବଂ ବାଡ଼େଇଲେ। ଆମ ଘର ଉପରକୁ ଟେକା ପଥର ଫିଙ୍ଗିଲେ। ଟେକା ମାଡ଼ରେ ମୋର ଗୋଡ଼ ମଧ୍ୟ ଖଣ୍ଡିଆ ହୋଇଛି। ସେମାନଙ୍କ ମାଡ଼ରେ ଆମ ସାହିର ବସନ୍ତ ନାୟକ, ଚୈତନ୍ୟ ନାୟକ, ଭ୍ରମରବର ନାୟକ, ବୁଧେଇ ଦେଇ ଖଣ୍ଡିଆ ଖାବରା ହୋଇଛନ୍ତି। ଏସବୁ ଦେଖି ମୋର ବଡ଼ ଭାଇ ଯଦୁମଣି ବେହେରା ଆଜ୍ଞା ଆମ ଘରୁ ଭୟରେ ପଳେଇ ଆସି ନାୟକଙ୍କ ଘର ପଶି କବାଟ ଦେଇଦେଲେ। କାଚେରା ଗ୍ରାମର ବିଦ୍ୟାଧର ସାହୁ
ଡାକି କହିଲା ଲୋକମାନଙ୍କୁ
ଶଳା ଏ ଘରକୁ ଆସ, ଏ ଘରେ ଯଦୁଆ ପଶିଛି। ସେ ଚାଳ ଉପରେ ଉଠି ଯାଇ ଚାଳ ଭାଙ୍ଗି ଦେଖିଲା, କହିଲା ଏଠି ଶଳା ଛପିଛୁ, ଶଳାକୁ ଧର। ଓ ଆଉ 3-4 ଜଣ ହାତରେ କଟୁରୀ, ଫାର୍ସା ଓ କାନ୍ତ ଧରି ଘର ଭିତରକୁ ପଶିଗଲେ ଏବଂ ମୋ ଭାଇ ଯଦୁମଣି ବେହେରାକୁ ଗଳିର ମଝିକୁ ନେଇ କଟୁରୀ ଫାର୍ସାରେ ହାଣି ଦେଇ ମାରିଦେଲେ। ମାରି ସାରି ତାକୁ ଧାନ ବିଲରେ ଫିଙ୍ଗିଦେଲେ। ବିନା ହାତରେ କଟୁରୀ, that is appellant number 1. ମାଧବ is appellant number 7, ଫାର୍ସା।
Tikkono is appellant number 3. Tangia. Gogana is appellant number 5. Kunta. Gonango Hasta, who is appellant number 4. O Sridhara Koturi Dharitile. Sridhara is appellant number 2. ପୂର୍ବରୁ ଆମ ସହିତ ତଣ୍ଡାଳ ଗ୍ରାମବାସୀ ଓ ବଡ଼ ସାହି ଲୋକଙ୍କର ବିବାଦ ଥିଲା। ଆମ ସାହିରେ ବସିଥିବା ଗୋଟିଏ ସରକାରୀ କୂଅ ଓ କୋଠା ଘରକୁ ନେଇ ବଡ଼ ସାହି ଲୋକମାନେ କଳି କରିଥିଲେ ଏବଂ ସେମାନଙ୍କ ସହ ଆମର ମନାନ୍ତର ଅଛି। ବର୍ତ୍ତମାନ ଆମ ଗ୍ରାମର 8 ଘର ଆଦିବାସୀ ଲୋକ କିଛି ସରକାରୀ ଜମି ଲିଜ୍ ନେଇଛନ୍ତି। ଏହାକୁ କାଚାରା ଗ୍ରାମବାସୀ ମାନେ ପ୍ରାୟ 1 ମାସ ହେବ ଆମକୁ ବିରୋଧ କରୁଛନ୍ତି। ଏଣୁ କଚାରା ଓ ତଣ୍ଡାଳର ଲୋକମାନେ ବଡ଼ ସାହିର ଲୋକମାନଙ୍କ ସହ ମିଶି ଆମ ଉପରେ ଆକ୍ରମଣ କରି ମୋ ଭାଇକୁ ମାରିଦେଲେ। ଆପଣ ଏହାର ବିଚାର କରନ୍ତୁ।
ଆଚ୍ଛା, ଏଇ ଯୋଉ ନାଁ ଗୁଡାକ ଏଠି କଟି ଯାଇଛି, ଏଠି ତ ଏଇ ବାହାରେ ଯୋଉ ନାଁ ଗୁଡାକ ଏପଟରେ ଅଛି ପେଜ 42 ରେ ଗୌରାଙ୍ଗ ପ୍ରଧାନ ହେଲା କେତେ ନମ୍ବର? ଯୋଉ ପେଜ 42 ଉପରେ
ଗୌରାଙ୍ଗ ଇଜ appellant number 4.
ଓ ତାପରେ
ମାଧବ ଇଜ appellant number 7.
ଶ୍ରୀଧର
ଇଜ appellant number 2.
ଆଉ ନାଁ ଗୁଡାକ ଏପଟରେ ତା ଛଡା ଆଉ 3-4 ଜଣ ଘର ଭିତରୁ ପଶିଲେ ଏବଂ ମୋ ଭାଇକୁ ଯଦୁମଣି ବେହେରାକୁ ଗହିର ମଝିକୁ ନେଇ ପଟୁରେ ସେଠି ମାରିଲେ। ମାନେ ଘରୁ ନେଇଯାଇଛନ୍ତି ବୋଲି ଇଏ କହୁଛନ୍ତି। ଏଇଠି କେତେଗୁଡ଼ା ନାଁ ଗୁଡାକ ଓମିଟ୍ କରିଯାଇଛି। ଆରେ ଇଏ ଅରିଜିନାଲ ଟ୍ରାଏଲ କୋର୍ଟ ରେକର୍ଡଟା ଅଛି, ସେ ମୋଡି ମାଡି ହେଇଯାଇଥିବ ସେ ଏଫଆଇଆରଟା, ସେଇଥିପାଇଁ ବୋଧେ ଏ ନାଁ ଗୁଡାକ ଏଠି ଉଠିନି। ହଁ ମଗେଇଦିଅ ଅରିଜିନାଲଟା। ଏଇଠି କେତେଗୁଡ଼ା ନାଁ କଟିଯାଇଛି। ବଟ୍ ଏଇ ଯୋଉ ପେଜ 42 ରେ ଆପଣ ଇଏ ପଢିଲେ ଯୋଉମାନେ କଣ ୱେପନ ଧରିଥିଲେ ଏବଂ ମାରିଲେ, ତା ଦେହରେ ଏଇ ଯୋଉ ଯିଏ ମରିଗଲା ତା ନାଁଟା କିନ୍ତୁ ନାହିଁ। ଆଉ ଟିକେ ଚେକ୍ କରୁ। ରାଜା କେଶର ରାଜା ଦେହୁରୀ is dead. His name perhaps is not there to have assaulted the
ଯଦୁମଣି ବେହେରାକୁ ଗଭୀର ମଝିକୁ ନେଇ କଟୁରୀ ଫାର୍ସାରେ ହାଣି ଦେଇ ମାରିଦେଲେ। ମୋର ଦିନା ହାତର କଟୁରୀ
ନାଁ ଗୁଡା ଲେଖିଦେଇଛୁ A1, A7, A3, A5, A4 and A2. That excludes A6. ରାଜକିଶୋର ନାଁଟା ଏପଟରେ ଅଛି କଣ ସେ ଜଣା ପଡୁନି। ଯୋଉ but he is dead, but we did not find that. So ଏଥଲାରୁ ଯାହା ଜଣା ପଡୁଛି ଗୋଟେ ଭିଡିଓ ଶୋ, ସେଠି କିଛି କମେଣ୍ଟ, ଇଏ ଗୋଟେ ଦିନର ଘଟଣା। ତା ପରଦିନ ମିଟିଂ ରେ ଆଉ ଟିକେ ଗଣ୍ଡଗୋଳ ଆରମ୍ଭ ହେଇଗଲା। ତା ପରଦିନ ଯୋଉଦିନ ମେନ୍ ଘଟଣା ହେଲା ସେଇଦିନ ରାଜଦେବୀ ନାଁ ଅଛି କୋଉଥିରେ ନାଇଁ ଏଠି ଯୋଉ ମେନ୍ ଏଟା ହଉଛି ଯୋଉ ପୂର୍ବ ଘଟଣା। ଏଇ ଯୋଉଟା ପଶିଲେ ଯୋଉଠି ମାନେ ଘଟଣାଟା ଆରମ୍ଭ ହେଇଛି ଯଦୁମଣି ଯୋଉଠି ପଶିଲା ତା ଭିତରେ ଏଇ ତଳ ଆଡୁ ଗୋଟେ ଚାଳ ଆଉ ଟିକେ ଉପରୁ ଏଇ ଜାଗାରେ
ଆମ ସାହିରେ ବସନ୍ତ ନାୟକ, ଚୈତନ୍ୟ ନାୟକ, ଭ୍ରମର ନାୟକ, ବୁଧେଇ
ସେଇଠୁ ଷ୍ଟାର୍ଟ ହେଇଛି।
ଭଣ୍ଡାରୀ ନାୟକ ଘରେ ବିଦ୍ୟାଧର ସାହୁ ଲୋକମାନଙ୍କୁ ଡାକି କହିଲା, ତାପରେ ଉପରକୁ ଗଲେ, ତାପରେ
ଏମାନେ ପଶିଲେ କେତେ ଜଣ, ସେଇ ଯୋଉ ପଶିକି ଏଇଠି
ମାଧବ ବେହେରା
ସେଇଟା 4-7-2 ରହିଗଲା। ଆଉ ବାକି ସେଇ ଆଉ 3-4 ଜଣ ଥିଲେ ମଧ୍ୟ ସେମାନେ ଧରି ଘରକୁ ପଶିଲେ।
ଦିନା ହାତରେ କଟୁରୀ
ହଁ ସେଇଠି କହୁଛି ସେଇ ଯୋଉ ସେଇ 6 ଜଣଙ୍କ ନାଁ ଆସୁଛି।
ୟାରଟା
ସେଇ ନାହିଁ 6 ନମ୍ବର
ଯୋଉ-
ନାହିଁ 6 ନମ୍ବର ରାଜକିଶୋର
କୋର୍ଟ ତ ଏଇଟା ହଉଛି ଆମର ଖୋର୍ଦ୍ଧା କୋର୍ଟ
ଏଇଠି ରାଜକୋଟ
ଆଡିସନାଲ
ଏଇଟା ହଉଛି ମେନ୍ ଇନସିଡେଣ୍ଟ
ରାଇଟ୍
ବାକି ସବୁ
ବ୍ୟାକଗ୍ରାଉଣ୍ଡ ଏଟା ହେଲା giving rise to
ହଁ।
ଏଇଟାକୁ ସେ ବିଶ୍ଳେଷଣ କଲା ବେଳକୁ କହିଛନ୍ତି ଯାହା ନାଁ ଅଛି ଏଇଠି
ହୁଁ।
ସେମାନେ କହିଛନ୍ତି ସେଇଟା ତେଣୁ କନସିଷ୍ଟେନ୍ସି ବୋଲି ସେ କହିଲେ
ଏଇ ଯୋଉଟା ନାଁଟା ଯୋଉଟା ଚାଳ ଉପରେ ଚଢିକିନି
ଅଦର
ଦେଖିଲେ
ନେମ୍
ତ ଏଇ ଯୋଉ ବର୍ତ୍ତମାନ ଯୋଉ 6ଟା ନାଁ ରହିଲା ଗୋଟେ ତ ମରିଗଲା ଛାଡି ଦିଅନ୍ତୁ 6ଟା ନାଁ ଯୋଉମାନେ ବଞ୍ଚିଛନ୍ତି ଯୋଉ 6 ଜଣ ଆପେଲାଣ୍ଟ ଲାଇକ୍ ଆପେଲାଣ୍ଟ ନମ୍ବର 1 to 5 and 7 ଏଇ ଯୋଉ ମେନ୍ ପୁରା ଲାଷ୍ଟ ଘଟଣାଟା କୁହନ୍ତୁ ଏଇ ଯୋଉ ଇଏରେ ଏ 3 ଜଣ ଯୋଉ ଆଇ ୱିଟନେସ୍ ଅଛନ୍ତି ସେମାନଙ୍କର ଭର୍ସନ କନସିଷ୍ଟେଣ୍ଟ ଆସୁଛି 1 6 ଆଉ 15 all of them 2 of them are related to the deceased one is an independent witness so far as ସେ ଯୋଉ ନେଇକିନି ଗହିର ମଝିକୁ ଯୋଉ ବାହାରିଲେ ଯୋଉ ତାପରେ ଧାନ ବିଲରେ ଫିଙ୍ଗି ଦେଇ ପଳେଇଲେ ବୋଲି ଯୋଉ ସେଠି ଯୋଉ ମେନ୍ 6 ଜଣ ପାର୍ଟିସିପେଟ କଲେ ହୋଲ୍ଡିଂ ଏଇ ଯୋଉ ୱେପନ୍ସ ଏଇଟା 1 6 ଆଉ 15 ର ଏଭିଡେନ୍ସ ରେ କନସିଷ୍ଟେଣ୍ଟ ଅଛି
ଆଜ୍ଞା
କାରଣ ଟ୍ରାଏଲ କୋର୍ଟର ଫାଇଣ୍ଡିଂ ହିଁ ହଉଛି ସେ ଯୋଉଗୁଡାକ କଣ୍ଟ୍ରାଡିକ୍ସନ ଅଛି ତାକୁ କାଟି ଦେଇଛି ସେ ତାଙ୍କୁ ଆକ୍ୟୁଟାଲ କରିଦେଇଛନ୍ତି ଏଇ ବୋଧେ ଏଇ 3ଟା ଏଇ ମାନଙ୍କର ନାଁ କନସିଷ୍ଟେଣ୍ଟ ଅଛି ବୋଲି ହିଁ କନଭିକ୍ସନ କରିଛନ୍ତି
but the medical exam
we'll go to that just ପଚାରୁଛୁ ଆମେ
ସେଇଟା ଏଠି କହିଛି seeing this my elder father out of fear tried to escape but he was chased by the accused Raja Devari, Dinabandha Devari, Goranga Pradhan, Sridhar Behra, Madhav Behra, Devan Pradhan, Tikram Pradhan and Ringaranjan Bhai. It is an accused Raja was armed with a purse while he was chasing my elder father. Similarly, accused Dinabandha was holding a button. Gagan was armed with a content. Accused was armed with
ଏଇ ଯୋଉ ଚିରି ଯାଇଛି ସେ ତାରି ଭିତରେ ଗୋଟେ ନାଁଟା ଅଛି ସେ ଯୋଉ
ଅଛି ଆମେ ଯୋଉଟା ଦେଖିବା
ସେଟା
ସେ କନସିଷ୍ଟେନ୍ସି
ହଁ
accused Madhava was armed with
ସେଗୁଡାକ ଅଛି ଜଣା ପଡୁଛି
ତାହେଲେ accused Goranga was armed with the person ଏଇଟାକୁ ସେ ରିପିଟ୍ କରିଛି
ଏଇଠି ସେ 6 ନମ୍ବର ନାଁଟା ଏଇ ଯୋଉ 13% ରହିଛି
elder father was taken and overpowered on the land of Orissa. He was entered by accused Raja Devri by means of person ବାରମ୍ବାର ଆସିଛି
ଇଏ କେସ୍ ଡାଏରୀଟା ଥିବ କେସ୍ ଡାଏରୀରେ ଜିଷ୍ଟ ଅଫ୍ ଦି ଏଫଆଇଆର ଥିବ ସେଟାକୁ ଦେଖି ତା ଦେହରେ ବେଳେ ବେଳେ ଥାଏ ଲେଖିଥାନ୍ତି ଏକ୍ଜାକ୍ଟଲି ଯାହା ହେଇଛି କେସ୍ ଡାଏରୀ ଯୋଉଠି ବିଗିନ୍ ହେଇଥିବ ଆରମ୍ଭ ହେଇଥିବ ସେ ପ୍ରଥମରେ ଜିଷ୍ଟ ଅଫ୍ ଦି ଏଫଆଇଆର ଲେଖା ହେଇଥିବ ନା କେସ୍ ଡାଏରୀ ସେଟା କଣ ନୁହଁ କମିଟମେଣ୍ଟ ଅର୍ଡର ସିଟ୍ କେସ୍ ଡାଏରୀ ତଳେ ଥିବ ଏଫଆଇଆର
calendar statement ଦେବନି
ନାଇଁ କେଜରେ ଦେଇନି ଏଇଠି ରହେ injunction report FIR
ଯୋଉ ଆର୍ଗୁମେଣ୍ଟ ନୋଟ୍ ଅଛି
ଏଇଟା ନା
ଆରଟାର ନାହିଁ ସେ ଯୋଉ ଭଲ୍ୟୁମ କରୁଛି ସେଟା କଣ ଗୋଟେ ପେପର ଗୋଟେ ଇଏଟା ଅରିଜିନାଲଟା ଯୋଉ ମଗଉଛ ବୁଝିଲ ତା ଦେହର ଦିଟା ଇଏ ଥାଏ କଣ 1 and 2 ବୋଲି ଥାଏ
Part 1,
ପାର୍ଟ
part
1 and part 2 ତାକୁ ଦିଟା ପକେଇ
A, B, C ଥିବ।
ହଁ
soft copy ଟା guess case diary ଟା আমি ପାଉନି।
ନାଇଁ
ନାଇଁ,
ନାଇଁ
ସେଟା
ପଠାଏନି ସେଟା ଦିଆହବନି ତମକୁ ଏଟା ରଖାଏନି କିନ୍ତୁ ଆମ ଏଠିକା ପାଇଁ ରେଫରେନ୍ସ
ଆଜ୍ଞା।
ସେଟା ନାହିଁ ସେ
ଜିଆରସି ଅନୁଯାୟୀ ପେପର ବୁକ୍ ର ଯେତିକ ପାର୍ଟ ଦରକାର ସେଗୁଡାକ ୟା ଦେହରେ ଅପଲୋଡ ହେଇଯାଇଛି ବାକି ଯୋଉଗୁଡାକ ସେଟା ରହିବା କଥା ଦେଖିବା ପାଇଁ।
161 ବି ନାହିଁ।
ମୋଷ୍ଟ ଲାଇକଲି ସେ ନାଁଟା ସେଇଠି ଅଛି ସେ ଯୋଉ ଚିରି ଯାଇଛି ସେଇଠି ବୋଧେ ଅଛି ଯେ ସିଏ ଗୋଟେ କଣ ଧରିଥିଲା କଣଟା ଧରିଥିଲା କହୁଛି କେତେ ନମ୍ବର ପାରାଗ୍ରାଫ ସେଟା ଜଜମେଣ୍ଟ ସେଟା ଜଷ୍ଟ ପଢୁଥିଲେ
ସେଟା ମୁଁ ପଢୁଥିଲି ଷ୍ଟେଟମେଣ୍ଟଟା ଡିପୋଜିସନ
ଡିପୋଜିସନ
ଡିପୋଜିସନ ଅଛି ହଁ ଡିପୋଜିସନ ଅଫ PW15
ତ ଫାଷ୍ଟ ଏଠିକି ପଳେଇ ଆସନ୍ତୁ PM ଡକ୍ଟର ପଳେଇ ଆସନ୍ତୁ ତାପରେ ଯିବା ଆଇ ୱିଟନେସ୍ କୁ ଯିବା
PW8 who is at page
ପେଜ କେତେ
405. 405 ତ? ହଁ। May I please signal?
ହଁ ପଢ।
I was working as pediatric specialist at GBS Hospital Khurda on 25/8/1994. On that day, on the direction of the SDMO and also on police requisition, I conducted PM examination over the dead body of the deceased Jadumani Behra, son of Pulamani Behra of village standard Jemamantadei, PS Begunia, District Khurda at 9:45 AM on identification of C1599B Pradhan and the relation of the deceased, namely Panu Porida and Lochan Behra. On examination, I found the following external injuries. Cut injury at the middle of right upper arm, cutting the skin and underlining muscle. There is a fracture of humerus bone at its middle. Size of the injury was 3:1/2.
half inch into 3 inches to half.
Again. Let's next page.
Cut injury.
Cut injury at the middle of the left upper arm, cutting the skin and underlining muscles. Size is 2:1/2. Cut injury 2 inch below lower angle of right scapula, cutting skin and muscle. The size of the injury is 3:1/2.
ଏଗୁଡାକ ଭିତରକୁ ରହିଯାଇଛି ସ୍ପାଇରାଲ ବାଇଣ୍ଡିଂ ପାଇଁ କରୁନାହାନ୍ତି ପୁରା ପୁରୁଣା ଅବଶ୍ୟ ଆଧେରି ବୋଧେ ହେଇନଥିବ ଓ ଅଛି ଓହୋ
PW8 ଡିପୋଜିସନ
ଆଚ୍ଛା ଏଥିରୁ ଯୋଗୁ ତ ଅସୁବିଧା ହଉଛି ନାଇଁ ସ୍କାନିଂ ଠିକ ସେ ହେଇଯିବ ଠିକ ଅଛି ଆଚ୍ଛା ଠିକ ଅଛି ଚଲ
Cut injury on the lower angle of right, 2 inch below the lower angle of right scapula, cutting skin and muscle. Size is 3:1/2. Fourth injury is cut injury on the anterior aspect of right leg, 4 inch below the right knee joint, cutting skin and muscle. The size of the injury is 2:1/2. Fifth injury is cut injury on the anterior aspect of right leg, 3 inch above the right knee joint, cutting the skin. The size is 1:1/2. 6 is cut injuries at 3 places on right foot of size varying from 1 to 3 long and half wide. There is fracture of right,
Second and third
and third metacarpal bones. Cut injury on the middle of the right leg, left leg, sorry. Cutting skin, the size of injury is 2 into half. Cut injury on the inner aspect of the left foot, skin deep. The size is 2 into half, skin deep. 9th, which your lordship will mark. Lacerated injury on the left frontal region, 1 inch above the left eyebrow, causing fracture to the underlying frontal bone. The size of the injury is 2 into half.
This is the finally.
No, this injury, you see, somebody suppose, let us say, holding this parsa tangia, marla bade bully jibo, epote jodi sharp side hele cut injury asibo, by chance marla bade bully gala bade asi jibo lacerated wound. So it cannot be excluded that by exactly କୋଉ portion ଟା hit କରିଛି ବି କହି ହବନି ତେଣୁ it's not that
Cross examination ରେ ABC
we will see that
on the section in the left frontal lobe of the brain matter and its 3 layers.
On dissection is found as follows. The left frontal lobe of the brain matter and its 3 layers of dura pia and anchoid matter are lacerated. The injuries noted above are all antimotor, which were found externally as well as on dissection. The cause of death is due to laceration of the brain matter and associated by multiple injuries on different parts of the body as
so it's cumulative effect. It is not only that injury, but it is associated with
multiple injuries on different parts of the body as indicated above. The time of death is within 16 to 24 hours. This is my report marked as Exhibit 14 and this is my signature marked Exhibit 14/1. I received a query containing certain questions from the IO to the SDMO Khordha on 23/9/94. In response to the query, I have sent a reply. This is my reply in writing marked Exhibit 15 and this is my signature marked Exhibit 15/1. Along with the query, the IO has sent 2 weapons of offense. One is Koturi, one is Gupti. Now, to opine if the injuries mentioned in the PM report could have been caused by those weapons. In my reply marked Exhibit 15, I mentioned that external injury number 1, 6 and 9 could be caused by Koturi. The rest of the external injuries could be caused by Gupti. At this stage, a sealed box received from the SFL is opened and 1 Koturi and 1 Gupti are brought up.
एगुड़ा तो recovery है ना नहीं किसी जो टांगिया वर्षा जो wooden portion था इतना देरे टांगिया रो wooden portion था बस से बड़ा recovery इनका 3 टा weapon दे
चलिए ये दीटा
Gupti
आओ
Koturi.
Yes.
This is the Gupti which is sent to me for my opinion. The witness identifies his signature on a paper slip attached to it, marked MO1. This is the Koturi marked MO2. The witness identifies his signature on a paper slip with seal affixed to the butt of the Koturi. External injury number 1 and 8 are incised wounds. Incised wounds will have length, breadth as well as depth. In case of external injury number 5, 7 and 8, the depth of injuries are skin deep. In case of external injury number 6, the bones was affected. The bone injury on humerus and on metacarpal bone were visible externally. I did not require any dissection to know that there was underlying bone injury at those places. I have not dissected injury number 1 and 6.
1 to 6.
1 to 6. Injuries number 1 and 6 were determined to be fracture injuries by simple touch and movement
of the
affected part. Since it was a case of postmortem, X-ray examination or radiological examination of the bony injuries was not conducted. It is not a fact that injury number 1 and 6 were not fracture injuries. A lacerated injury is always the result of a hard and blunt substance. Injury on the left frontal region has caused laceration to the brain matter and tearing of dura pia and anknoid. It is not a fact that I have not mentioned in Exhibit 14 that injury number 9 corresponds to laceration of brain matter and tearing of dura pia and anknoid. The sharp edge of MO2 was not used to cause injury number 9. It is a fact that I have not mentioned in Exhibit 14 that the death of the deceased was due to shock and cumulative effect of all the injuries. It is possible that the brain material could be lacerated without fracture of scalp bone. It is not possible that there could be laceration to brain material without a head injury. There cannot be laceration to the brain material unless head comes in contact with a hard substance. I have just mentioned in Exhibit 14 that the cause of death was due to laceration to the brain matter. External injury number 9 could be caused by fall. It is not a fact that my report, Exhibit 14 and 15 are unscientific.
ये जो डिसीज जो आसी पशिगला PW3 रो घरे पंडारी घरे से गोटे आखि से चाळ ऊपर कोणा करी देखिला सेटा ताकि तले जाई ता घर भितर के माने पसिले केन व्हाट इज द एविडेंस ऑफ द विटनेसेस कोन घर जो कबाटा भांगी किनी ना अंति ये जाइथियो माने कबाटा तो नहीं व्हाट इज
सी एफआईआर कोची ना सी
माने दे रन अवे फ्रॉम दैट हाउस फ्रॉम द बैक साइड
पछपटु बाहरला तापर ताकू ड्रैग
चेंज करले ड्रैग करे नहीं गले बोली कुछ
ता भितर निजे
डिस्ट्रिक्ट एंड देयर फैमिली आल्सो एंटर इन द
बैकवर्ड बाहरिची
डिस्ट्रिक्ट एंड हिज फैमिली
ताकू ड्रैग करले
आउट ऑफ हियर दे आर एंटरिंग इन द PW3 हाउस
ना सेटा पछ कथा कोन आफ्टर ही एंटर्ड इनटू द हाउस ऑफ पंडारी
सेटू जेतो PW3 घरु को जेतो पसी होला
ताकू ड्रैग करले
माने चाळ ऊपर जेतो देखले आइडेंटिफाई करले से बैक साइड रे बाहर को जाउतला
ओ अच्छा
माने जेतो पसी गले ये
बैक साइड रे बाहर को
बाहरला बेलको
से ताकू चेंज करले
ड्रैग करकी
the PW1 and
उसे कहीं just a clarification. And IO or the scientific officer has come to the spot or only IO?
Scientific officer
से जो घर भितर ता माने किसी ब्लड पाइने माने एंटायर इंसिडेंट ता बाहर है
There is no scientific
आईओ भी कौन सी ब्लड फॉर ता भितर पाइ कारण या जदी हेची से माने ऑब्वियसली ता भितर और रक्त नथियो से सब तो जाति से जो कियारी रे पड़थियो ताहा कियारी सेटा उठ धान बिल रे
पद्मला
से जो दीटा मटेरियल ऑब्जेक्ट से भी किछि ब्लड पाइले सेटा केमिकल रिपोर्ट एग्जिबिट
PW1 ର ପାରା 5 ରେ ସେ କହିଛି
दैट मींस ये जो बाहरी किनी जाउथिला पछपटु जो डिसीज ए माने ताकू धरी किनी टाणी किनी से जो धान किलो
Seeing this, my elder father out of fear,
if I place this
so the back door of the house of a Pandiri, like, and in fact, he ran through the back door, but he was chased by accused Raja Deuri, Dinamandu Deuri, গৌরাঙ্গ প্রধান, শ্রীধর বেহেরা, মাধব বেহেরা, গগন প্রধান, and Niranjan Naik. He was also seized by other accused persons.
Then the assault took place in that.
Accused Raja was armed with the farsa.
That is the other case. So then let us come to the eyewitness system. You read first PW, the first witness, PW
One.
Muni Mehra is the daughter of PW 15 and niece
of deceased. 375. That's my implicit.
Yes, sir. Hold on.
I know the accused persons in the dock. They belong to village Tandar, Pachera, Bodosai, Nuasai. The occurrence took place on 24/8/94 at about 8 a.m. The occurrence started from our street, Sahi, but the murder took place on the land of Padmalav Sahu. The land of Padmalav Sahu, situated in Moja, Kochera, that land is about 300 yards from my house. I am the daughter of Madhu Behra, the informant of this case. On the date of occurrence,
Madhu Behra is PW 15.
On the date of occurrence, all the accused persons armed with lathi, thenga, deadly weapons like bhali, konta, farsa, etc. Honto and farsa, etc. started damaging our house from 8 a.m. onwards. When these accused persons came to our house and started damaging our house, I myself, my father Madhu Behra, elder father Jadumani Behra, my mother Sisula, my elder mother Jahaj, and others fled away to the house of one Pandari Naik of our street out of fear of our life. Having taken shelter in the house of Pandari Naik, we closed his front door in fear of life. When we had taken shelter in the house of Pandari Naik, one Vidyadhar Sahu of village Kochera shouted aloud that we had taken shelter in the house of in the house of Pandari Naik. Accused Vidyadhar thereafter climbed up the roof of Pandari, which was a thatched one. He made a hole on the thatched roof by taking out the straw. Having noticed my elder father and us inside the house of Pandari Naik, Vidyadhar Sahu told the other accused persons who were standing in front of the house of Pandari that my elder father was inside the said house. As a result of that, the accused persons started breaking the door of the house of Pandari Naik. Seeing this, my elder father, out of fear, tried to escape through the back door of the house of Pandari Naik, and in fact he ran through the back door, but he was chased by accused Raja Dehuri, appellant 6, Dinobandhu A1, Gourango is A4, Sridhara is A2, Madhav is A7, Gagan is A5, Tikon is A3, and Niranjan Naik. He is not an appellant.
Right.
He has been acquitted with
and he was also chased by other accused persons. Accused Raja, appellant number 6, who was dead, was armed with farsa while he was chasing my elder father. Similarly, accused Dinobandhu was holding a kotari. Gagan A1. Gagan A5 was armed with konto. Accused Tikon, who is A3, was armed with tangia. Sridhara, who is A2, armed with Koturi. Madhav was armed with Farsa. Madhav is A7. And Goranga, who is A4, was armed with Farsa. All other accused persons were also armed with lathi, thenga, and deadly weapons. My elder father was overtaken and overpowered on the land of Padmalav Sahu. He was attacked by accused Raja Dehuri, appellant number 6, by means of a farsa on the land of Padmalav. The accused Raja Dehuri, appellant number 6, attacked the right side shoulder, backside of my elder father by means of farsa. Accused Dinobandhu, appellant number 1, assaulted my elder father to his right hand upper arm by means of koturi. Tikkon is appellant number 3, dealt blows by means of a tangia to the right leg of my elder father. Thereafter, other accused persons whom I have named above also mounted attack on my elder father with the weapon of offense with which they were armed with. All other accused persons of this case also had also surrounded my elder father. When my elder father was chased by the accused persons towards the land of Padmalav, I also got out of the house of Pandari Naik and went close to a mango tree which is about 40 yards from the spot. I stood there and watched the assault perpetrated by different accused persons on my elder father. Half an hour after the assault began on my elder father, I went to the land of Padmalav Sahu from underneath the mango tree, only to find my elder father lying dead with bleeding injuries all over his body. I noticed, as far as I remember, 9 cut injuries on my elder father. The injuries on the backside of the right scapula, 3 injuries on the right leg, 2 injuries on the right hand, 1 injury on the left hand, 1 injury on the left leg, 1 injury little above the right side eyelid, that is on the right frontal bone. My elder father and other villagers of Tanda, where we were residing on the date of occurrence, have taken lands on lease from the government. We have constructed our houses there. That is why the accused persons were hostile to my elder father and other villagers. Cross-examination. All the villagers to which the accused persons belong were objecting to our lease. I was examined by the police on the date of occurrence itself. It is a fact that I have not stated before the police that all accused persons had dispute with us regarding the lease land. Although I have stated that there was a dispute for such lease, it is a fact that I stated before the police that my elder father and others had dispute with the villagers of Kochera alone regarding the lease. It is not a fact that I had not stated before the police that my father and elder father had taken lease of government land. Some of the accused persons also in between the land of Padmalav where my elder father was assaulted and the place where I was standing and watching the assault. Some of the accused persons were also in between the land of Padmalav where my elder father was assaulted and the place where I was standing and watching the assault. I had come alone to the mango tree and stood there to watch the assault on my elder father. It is a fact that I have not stated before. It is not a fact that I have not stated before the police that I came out of the house of Pandari Naik and stood under a mango tree to witness the assault on him. I have not seen more than 7 persons whom I have named above to have assaulted my elder father. It is not a fact that I have not stated before the police as to which accused assaulted to which part of the body of my elder father. It is not a fact that I have not stated before police that I saw a cut injury above the right eyebrow, which means to the injury number 9. My father had confined himself inside the house of Monguli Naik when my elder father was assaulted.
Eyewitness PW 15.
15.
Mongoli Naik is PW?
No, Monguli Naik is
Not examined.
Monguli Naik. No, he has not been examined.
My father on PW 15.
15 had confined himself inside the house of Monguli Naik when my elder father was assaulted on the land of
Elder
Padmala.
father is deceased.
Again, Jaduman. There is only one Madhu Behra in our village, and he is my father. There was nobody else of our village in the room in which our family confined ourselves when we took shelter in the house of Pandari Naik. There was nobody else of our village in the room in which our family confined ourselves when we took shelter in the house of Pandari Naik. No other villagers of our village were standing near me and watching or witnessing the incident of assault on my elder father. The house of one Anuporida was alone damaged when we left our house to take shelter in the house of Pandari Naik. By the time police came to the spot, our village, we had shifted our elder father from the land of Padmala to a place which is in front of the house of Pandari Naik. We kept the dead body of our elder father under a coconut tree which is in front of the house of Pandari Naik. Accused Kaibalya Dehuri had a quarrel with my brother Lochan Behra little earlier to the occurrence. On 24/8/94, Lochan Behra was present in the house during the occurrence. He has not been assaulted by anyone. I cannot say where accused Kaibalya went having quarreled with my brother. It is not a fact I had not seen the occurrence at all. It is not a fact that my elder father has not died due to assault of the accused persons. It is not a fact that accused persons were not armed with any kind of weapons. It is not a fact that I am deposing falsely at the instance of my father.
Who is the IO of this case?
No, the IO is PW 16 and 17. Girija
ना ये statement टा की record कर दी confrontation कर दें तो
PW
16.
page number
441.
441.
Page 448. 41.
441.
441 to around
Relevant is at page 448.
IO PW
Paragraph 22 रे contradiction.
IO कितने 448
448, 32.
Paragraph 23.
32.
448 एक नंबर कौन पचारजंती पचार इटा एक नंबर तो हमें पढ़िलु ना
Again,
पारा 32 हम
I examined Chini Behra, PW1. Jhunni set actually हो Chini ले.
तो हेलो हेलो जूनी तो जूनी बेरा PW1
It is a fact that PW1 has not stated before me that her father and elder brother had taken lease of government land, that she came out of the house of Pandari Naik and stood under a mango tree to witness the assault on Jadu, that she saw a cut injury above the right eyebrow.
So, what are your comments on this witness PW1?
No, first and foremost thing is she has stated.
You give the comment witness wise, then as a case role wise. So, what is your comments on this particular witness PW1? Why you disbelieve this PW1, who according to you may be related to the deceased and also to the informant? So, what is your submission?
First and foremost thing is in the chief, she has stated that I myself, my father Madhu Behra and elder father Jadumani Behra and mother Sishula and elder mother Jahaj and others had fled away to the house of one Pandari Naik.
PW3.
Again, in the cross, she states that her father has confined himself in the house of one Mongoli Naik.
Kettavale at one time.
During the
No, that's
Assault.
Again.
During the
really
assault.
assault. Question is, you may say that how can be PW15 be eyewitness when our daughter himself says that he had confined? That is one aspect. We were asking you, what are your comments on PW1's evidence as an eyewitness? He stated that he was at a particular place watching it
from 40 yards of the mango tree.
That of course you have proved through the IO that part he has not stated, that he went to that place, stood there and saw the occurrence. That is the only contradictions you have brought out. Otherwise, what is the other thing why you would disbelieve the evidence of PW1?
She has also categorically stated that the deceased was surrounded when he was mercilessly assaulted.
Yeah.
And other persons were there in the vicinity, which she has stated, in between the land of Padmalava and the place where she had. So it was not possible to see as to who attacked with which weapon and the manner and at which particular place the assault was attributed on the body of the deceased.
She has brought in the story of assault injury number 9, which she has not stated.
And the fact that she has brought in the injury, or that is injury number 9,
No, he has named these appellants who was holding what weapon, number one. Number two, so far as at the time of assault, regarding the body part which you are mentioning, he has named only 3 accused persons, appellants. Six assaulted on the right shoulder, Parsa. Then appellant number 1 assaulted right hand, and appellant number 3 assaulted on the right leg. Then tinita body part jo kochi baki se kochi onne mane mo bapa ku mounted the attack by onne manakar omnivously se kochi ei 3 janakar kochi kiye right hand re marla, kiye right shoulder re marla, au kiye right leg re marla, eti kochi. But that is consistent because there is no contradictions point out with reference to his or previous statement. So this part is there. So the only, if you visualize the situation, only 8 persons were there. 1 is the deceased, 7 are the appellants, and she was standing at a distance of about 30 feet, 40 yards from a mango tree and watching it. And it's a daytime and occurrence is there. It is not that there were 100 persons so that he could not see that which part he was assaulting, or visibility is a specific rule that 7 persons were there who was holding which weapon, and 3 of them assaulted on this part. Others general statement is there. But consistency is in the implication of these 7 persons, out of which 1 is died, and to that effect, no contradictions have been proved through the IO. That is how we are asking you that what are your comments on this particular witness. One is individual comment, then other is the general comment on the case itself. And so we have noted down also your points that one particular injury is a lacerated wound, and the weapons which the accused persons are holding, mostly sharp cutting edges are there. In spite of that, the doctor has stated that one of the that lacerated injury can be caused by this cautery. Mane blunt side jodi use hobo pachchapotata, sharp side নহলে भी possible hobo seta. Apart from that, the other weapons like tangia and farsa, which used to carry a stick portion also, that was perhaps not seized and not produced before the medical officer for obtaining his opinion. So
only two seizures have been
two
detected.
seizures, right.
Gote gupti and gote koturi.
The other weapons were not
Tangia.
seized. Right, you are right.
Now, the fact that these tangia koturi is very much locally available in all these villages during that time.
We are putting you, it may be locally available, obviously it will be there.
They were all farmers, so it was.
So that is the question is that when an eyewitness to the occurrence implicate these 7 persons specifically, that they were what they were holding and where the occurrence took place, how the occurrence took place, and some of them assaulted on which part of the body, and others as generally. And doctor's evidence does not completely rule out that no, by any such weapon, these injuries are not possible. So whatever was produced before the doctor by the IO after its seizure, he is as opined that this is possible. Now we'll see that what are the contradictions between one witness, the other eyewitness, if there is otherwise individual comments on your witness, what is the specific comment on this particular witness, that we are asking you so that we can take note of it. Have you prepared a note of argument?
But I have prepared a rough note of argument.
In your note, just focus on this, that individual, your submission on PW1, and then as a whole on the
with respect to other witnesses. The individual aspect which I am placing, my lord,
is the place where if it is a 40 yard, 40 yards,
120 feet.
120 feet, and it's a daytime. It's not that so.
But we have to also take into consideration that there is a ruckus going on, my lords. See, the deceased is surrounded by so many people.
7 persons, not so many persons.
7 people, even if 7 people are concerned, my lords, let us consider. When 7 people have surrounded somebody who is being assaulted, my lords, it is.
That is why she stated that I have just noted down these 3.
Exactly, my lords.
Others I could not.
Exactly.
They all assaulted, but
then the question will arise that these 3 persons and these witnesses, none of these witnesses who implicate all these appellants, that is PWs 1, 6 and 15, neither speaks of the presence of the other witnesses.
No, they were at different places.
Let them be at different places. They are at different places.
One is near that mango tree.
I concede, my lords.
Yes.
The other aspect your lordship will consider is that these 3 are not the only eyewitnesses. These 3 are eyewitnesses to the assault on the deceased.
Yeah.
Beside them, my lords, there are other eyewitnesses who have spoken about the incident. They don't speak about the presence of these persons. They don't speak about the assault on the deceased. Everything has taken place near the village, or in broad daylight, as your lordship is saying, on the field, on the outskirts of the.
No, we are not saying that is the prosecution.
Exactly, my lord. That's what.
Because that is the when we read the judgment, it was placed, and we find that learned trial court has placed reliance on the version of these 3
exactly
witnesses.
No, let him read the evidence then.
No, no, it's all right. We are just asking, perhaps he might have noted down that individual comment, that is why we asked him. Okay, now you are to go to the other witness, PW 6.
And first your lordship may see PW 15, then go to it.
Okay, PW 15. Good, that's it.
Page 433,
33.
Again. My lords, may I please sit?
Just. Please.
I know all the accused persons in the dock. I am the informant of this case. The deceased Jaddu Behra is my brother. The occurrence took place 3 years back in the birth of Bhadrav on a Wednesday. On the date of occurrence at about 8 a.m., I was sitting on the veranda of my house where my nephew Lochan and my elder brother deceased Jadumani were residing.
Lochan is PW 3.
PW3 is Pondari.
Lochan
has not been examined, my lords. Little before, it will be little, I believe, my lords. Little before 8 a.m., accused Kaibalya picked up a quarrel with my nephew Lochan regarding the incident which had taken place earlier to the actual date of occurrence. I tried to pacify them, saying that whatever had happened had already happened. I further told them not to quarrel. On my intervention, Kaibalya left the place. Only 5 minutes thereafter, all the accused persons came to our house armed with deadly weapons such as bhalli, kunta, farsa, lathi, koturi, etc. Thereafter, the accused persons started damaging our house and also ransacked our properties. Seeing the violent mood of the accused persons, I myself, my wife, my children, my elder brother Jadumani, his wife, his children all left for the house of Pondari Naik to take shelter there. We did this out of fear of our life. After the accused persons broke down and demolished our house, ransacking the properties, came to our house of Pandari Naik. Before they came to the house of Pandari Naik, they also demolished and broke down the houses of other persons which lie in between my house and that of Pandari Naik. After some time, I heard accused Vidyadhar Sahu while sitting on the thatch of the house of Pandari Naik telling and shouting that my deceased brother had taken shelter there. In order to locate us, including my brother, accused Vidyadhara pulled out the thatch to see through the same. When the accused Vidyadhara announced to other accused persons that my brother had taken shelter in the house of Pondari Naik and has concealed himself there, out of fear we opened the back door and tried to escape. Out of fear we opened the back door and tried to escape. My brother was chased by the accused persons. Amongst them, in particular, accused Raja, appellant number 6, Dina is appellant number 1, Gauranga is appellant number 4.
Dina is appellant number 1.
Dinabandhu is
Raja.
Raja is appellant 6. He has died. And Gauranga is appellant number 4. Tikki Naik is appellant number 3. Sridhara is 2. Madhav is 7. And
He is not appellant 3.
Tikki Naik is not appellant. Tikki Pradhan, letter comes.
Tikkan Pradhan is appellant number 3.
Tikki Naik is not there.
Tikki Naik is not there, I'm sorry.
So Tikkan Pradhan.
Tikkan Pradhan is appellant number 3.
And Gagan Pradhan.
Gagan is appellant number 5. Were present. They were all armed with Thenga, Bhalli, Kunta, Farsa and Koturi while chasing my brother Jadumani. my brother Jaldumani ran towards the paddy field of Padmalav Sahu. There he fell down. There he was assaulted brutally on the above
By the
named
above
persons, by the above named person. I was assaulted by accused Brundaban Deuri and Gauranga Pradhan, who is appellant number 4, by means of a
Brick
bat.
Brick bats.
Brick bat. I sustained bleeding injury on my both the legs, so I could not go out to rescue my brother.
So he has been examined medically.
हाँ এটা হচ্ছে PW রুহন্তু
9 is the doctor.
9
The exam the
Yes.
হরিহর পটনায়ক
PW 9 doctor. He examined PW 15, na?
Injured ମାନଙ୍କୁ exam.
ଆଉ କେତେ ଜଣ injured?
अच्छा. नहीं, खाली PW 15 तक वो हम लोग क्या प्रॉब्लम. So
नहीं, he has not
4, 11,
examined
18, 19,
PW
19.
15.
हाँ.
He has not examined.
For PW 4, 11, 18, 19, 4 injured person has been examined by the doctor.
नहीं,
PW
15
की-
15 has not.
Pandora has not been examined.
अच्छा.
So far as PW 15 is concerned, a police requisition was made for his examination.
But nobody.
But there is no injury reported.
Hmm. Assaulted by swans of big bats, assaulted, sustained bleeding injury, but both legs.
So I could not go out to rescue my brother. I got stuck up in the body of Mongoli Naik because of the assault on me. But the land of Padmalav Sahu was clearly visible to me from the body of Mongoli Naik. The land of Padmalav is about 200 cubits from the body of Mongoli Naik. When the accused persons dispersed, our family members went out to the land of Padmalav Sahu and brought my elder brother Jadumani, but by then he was already dead. His dead body was brought and placed near a coconut tree close to the house of Pandari Naik. During the incident, my co-villagers, namely Chaitanya Naik, Basanta Naik, Budhei Dei, Ramesh Naik, Palikar Dei, Kulamani Behra were also injured, having been assaulted by the accused persons. There was tension between the members of our street and that of the accused persons regarding lease of government lands in favor of inhabitants of Sano Sahi. However, the proximate cause of this incident took place on Monday night in a video show. In that video show, which was attended by my niece Basanti, accused Dinobandhu, appellant number 1, passed some ugly comments. The matter was reported by her to my younger brother Mathura. On the next day, there was a meeting, but nothing could be settled. Rather, was an incident of brickbatting on our houses by some accused persons. Finally, it gave rise to the incident on Wednesday. I am an illiterate person, so I verbally reported about the incident to the police who came to the spot. I gave this oral report around midday on the date of occurrence. Police reduced my oral report into writing, read over its contents to me, having found the same to be true and correct. I affixed my LTI thereon. Cross-examination.
ମାନେ ଯୋଉ ଯେତେବେଳେ ଇଏ ଉପରୁ ଚାଳ ଇଏ କରିଛି ସେମାନେ ସବୁ ବାହାରିକିନି ମାନେ ଜଣେ ପଳେଇ ଯାଇଛି ସେ ମଙ୍ଗୁଳି ଘର ବାରି ପାଖକୁ
ତାକୁ ମାଡ଼ ହେଲା ବେଳକୁ ସେ ମଙ୍ଗଳି ପାଖରେ ହିଁ ରହିଗଲା
ଆଉ
ଯାଇପାରିଲା
ଇଏ ଆରଟା ରହିଯାଇଛି ସେ ଆମ୍ବ ଗଛ ପାଖରେ
ଇଏ ଦୌଡ଼ିକି
ଘଟଣା
ପଳେଇ
ହେଇଗଲା।
ଯାଇଛନ୍ତି
ହଁ yes next
There are only 18 families in Sanosara Sahi. Prior to settling down in Sanosara Sahi, we had our hutments in Bodasara Sahi. We have settled down in Sanosara Sahi from 1982. I cannot give the plot number and khata number of the land which is under our occupation in Sanosara Sahi, but it measures 60 decimals. Out of 18 families, 8 families have received government patta for their land. The land where 18 families in Sanosara Sahi have settled down was a Gochar land. Again says it was a communal land. The patta issued by government and rent receipts therefore are with us so far as 8 families are concerned. We showed our patta and rent receipts, but the police has not seized the same. Ramesh Naik, Sushen Dehuri, Bina Naik, Panu Porida, Chaitanya Naik, Kumar Naik, Pondari Naik, Gunduchi Naik, who belong to Sanasoro Sahi, have not received patta for the land occupied by them to my information. The houses of the above named persons have been demolished on Wednesday incident. It is not a fact that government agency has broke down our houses as because we are in illegal possession of the government land. At present, we are not residing in Sanasoro Sahi, where we had houses earlier. Now we have settled down in Hontabad without permission. We have constructed our hutments on government land. I was not present in the video show which took place on Monday night. I have also not attended the meeting held on Tuesday evening. 60 to 70 persons came to our house 5 minutes after the accused Koibalya left the place, quarreling with my nephew. I know all of them by name. I have told the names of all accused persons when the oral FIR was lodged. I have the names of I gave the names of 97 persons to the IO who reduced the FIR into writing. Police reduced the list to the number persons who name find place in the FIR. 60 to 70 persons had participated in the incident. Again says 97 persons participated in the incident. I have not protested to the court for IO deleting the names of some of the accused persons. I told the IO while lodging FIR that I was injured by accused Gauranga and Brundavan due to their brick batting. I also told the police about the assault on me due to brick batting. It is not a fact that it is not mentioned in the FIR that I was assaulted by the above named two persons due to their brick batting. It is not a fact that I have not so stated during my examination under 161 CRPC. It is not a fact that I have not stated at all about the assault on me. I have not seen any injury on the person of Chaitanya Naik, Kalika Budhei, Ramesh, Kulamani and Basanta due to brick batting. The person named above were not assaulted simultaneously. I saw the injuries on the above named persons after they sustained injuries. I saw them to have gathered in the backyard of Pandari Naik. Chaitanya Naik, his wife Budhei Dei and daughter Kalika Dei were also in the backyard of Pandari Naik. All the above named persons were assaulted in the backside of the houses. When I got stuck in the barry of Mongoli Naik, he himself and his children were present in his house. They shifted me to the front side of their house. The distance between the barry of Mondari Naik and Mongoli Naik is about 15 cubits. The land of Padmalochan is about 200 cubits from the barry of Mondari Naik. Paddy was sown on the land of Padmalochan Sahu. It was muddy then and paddy sapling have come up. The land of Padmalochan also ridges all around. Its height may be 10 inches. I saw the injuries on the persons of my deceased brother after he was brought near the house of Pandari Naik. The land near the coconut tree where the dead body of the deceased brother was kept was also stained with blood. Jadumani was not assaulted by any one of the accused persons before he fell down on the land of Padmalav. It is not a fact that my brother died as because he fell down on the land of Padmalav and that no one had assaulted him after he fell down there.
This suggestion is not a good suggestion. How can then be injuries that incised on caught? All right, carry on. Narrow.
I do not remember if Chaitanya had injuries due to lathi blow. It is not a fact that I have not seen any part of the incident. Out of fear, we took shelter in the house of Pondari Naik, and there is no special reason for our taking shelter there. The Grammarokhi of our village was not summoned to the village after the incident. I cannot say if Mathura had seen any part of the incident. I have not seen Mathura at the spot. As police arrived on the spot, I came to know that Mathura had gone to the police station. I have not seen anyone to bring police to the spot. Police came to the spot, the injured persons went for medical help and treatment. Out of the injured persons, I was alone present at the spot when the police came. I have not talked to the injured persons before they went for medical treatment. 10 to 12 accused persons had entered inside the house of Pondari Naik. The front door of Pondari was broken. I have stated before the police while lodging FIR that some of the accused persons made a hole on the wall of Pondari and entered into his house. I have not stated before the police that some of the accused persons entered through the thatch of Pondari by breaking open the same. It is not a fact that this is a concocted case, and it is not a fact that the accused persons are not concerned with the case. I have given a list of articles ransacked from our house to the police. There was no litigation pending between the inhabitants of Sanosaro Sai and the accused persons prior to incident.
And only one contradiction is there, page 451. Now, I've examined Madhu Behra. It's not a fact that PW15 has stated before me. Both his legs were injured due to kickbatting of the accused Gauranga and Bundam. That's all. Apart from the 7 appellants, 3 to 4 others were there who had entered inside the house of PW3, but out of them only 7 went to that land and with weapons and assaulted. That is the evidence of 1 and as well as 15 others. 15 ବି ସେଇଆ କହୁଛି ଯେ 10-11 ଜଣ ତା ଭିତରକୁ ପଶିଲେ ସେ ଲାଇନଟା କୁଆଡେ ଗଲା ପୁଣି 10-15 ଜଣ ଖଣ୍ଡେ ପଶିଲେ କିନ୍ତୁ ତା ଦେହରୁ 7 ଜଣ ଯାଇଛନ୍ତି ସେ ଲାଇନଟା କହିଲା 10-15 ଜଣ ପଶିଲେ ବୋଲି
ଏଇଟା para 5 ରେ
para 5 ରେ
para 5 ରେ ସେ କହୁଛି about these appellants and then he further states that
10-15 ଜଣ ଖଣ୍ଡେ ପଶିଲେ ତା ଘରକୁ କିନ୍ତୁ para 21 is 10 to 12 accused persons had entered inside the house of Pandari Nayak, PW3. ତାପରେ ଇଏ ଗଲା ପରେ ଏଇ 7 ଜଣ ତା ଦେହରୁ ଯାଇଛନ୍ତି ଚେସ୍ କରିକିନି ବିଭିନ୍ନ ୱେପନ୍ସ ଧରି ମାରିଛନ୍ତି। Lunch continue. We'll continue after lunch, huh?
my lord.
Pardon to mention my lord, item 7. That was wrongly disposed of because भूल टाइप कर देथिले annexure 1. Annexure 3 टा हला certified कर. Item 7 टा. Item annexure 3 टा हला certified copy. Claim tribunal order टा claim tribunal already are now not functioning. Certified copy could buy.
That order has been already typed.
ଆଉ କୋଉଠି ସାର୍ଟିଫାଇଡ ମିଳିବନି କ୍ଲେମ୍ ଟ୍ରିବ୍ୟୁନାଲ ଆଉ ଫଙ୍କସନ କରୁନି କାଇଣ୍ଡଲି direct to return the same by replacing
Once you file, those documents are necessary. So that has been stamp reporting तारी basis रे सब ऐसी disposal ହେଇଗଲା ମାନେ କଣ ଆମେ certified copy ଟା ମନେ କର ଆଜି ଆପଣ criminal appeal ଟେ file କରିବେ ତା ଦେହରେ certified copy ଦେବେ trial court judgment ର କାଲ ସକାଳେ criminal appeal ର judgment ହେଇଯିବ ବୋଲି ଆମେ କଣ ଆପଣଙ୍କୁ trial court judgment ର certified copy ଟା ଫେରେଇ ଦେବୁ
honorable directed to approach the civil court.
Whatever it may be, that is part of official record. How can it be
functioning? That's why
ଆମେ ଆପଣଙ୍କୁ liberty ଦେଇଥାନ୍ତୁ ଯେ ନାଇଁ ଏଠି ଇଏ ନା ଆମେ ଗୋଟେ merit ରେ ଆପଣ order ଟା pass ହେଇଛି ତାପରେ that's a part of the record. How can we say give the certified copy? Yes, next.
My lord, the petitioner is in custody for more than 10 years.
No, don't mention today, mention tomorrow. Yeah.
The next eyewitness is PW6. Yes, 396 of the paper.
Yeah.
He says, see, page 397.
Yes.
I have a piece of cultivable land at a distance about 600 yards from my house. Just before the incident, I had gone to my field. While returning, I found the accused to have armed themselves with lathi, bhala, farsa, koturi, tangia, and other deadly weapons. They had assembled at the house of Jadumani. I found them to have completely demolished his house. I also found them to have ransacked the same. Thereafter, they came to my house and started demolishing the same. I protested the accused for their high-handed action. I got no reply from them. Accused Brunda Dehudi identifies him in the dock, who was armed with a koturi, made an attempt to assault me by means of the said weapon. I avoided the attack as I moved to a different position. In the meanwhile, accused Niranjan dealt a lathi blow to my right scapula. After the assault, I sat down on the ground due to pain. Thereafter, accused moved towards the house of Pandari. Vidyadhara Sahu identifies in the dock, climbed the roof of Pandari, made a hole on the thatched roof. Thereafter, he located Jadumani, his family members inside the house of Pandari. Having so done, he shouted aloud, saying that deceased Jadumani and his family members concealed themselves in the house of Pandari and exhorted upon his co-accused to demolish the house of Pandari. When the accused started breaking and demolishing the house of Pandari, Jadumani fled away through the back door. As he fled away through the back door, Dina Dehudi, Dinabandhu, Raja Dehudi, Gagan Pradhan, Dinabandhu hela 1, Raja hela 7,
6 dead.
No, 6 dead.
Aye. Gagan Pradhan 5, Tikan Pradhan 3, Gauranga, this is number 4, Sridhara, number 2, Madhava, Number 7, chase the deceased. They were armed with Katuri, Farsa, Kunta, Tangia, and Lathi. When they chased the deceased ran towards the land of Padmalab. He was overpowered and overtaken on the land of Padmalab by the above named accused, such as Dinabandhu, Raja, etc., where he was brutally assaulted with the help of the arms with which they were armed with. Other accused, whom I have not named specifically, also chased the deceased behind those accused whom I have named. So apart from these 7 whom he names, he says others have also chased the deceased. Cross-examination. I was examined by the IO between 4 to 6 days. Police had seen me on the date of occurrence, but I was not examined. Police had seen demolition of my house. They belonged to Begunia PS. Police also came to the village on the day following the incident. I had gone to hospital on that day. I was sent to hospital for my medical examination. On the date of incident, police sent me to the hospital. It's not a fact that I have not stated before police that the accused demolished the house of Jatu. I had gone to the field with a kodi with my hand. I have seen Madhu, Kulamani and others of Sanasara side when I returned from the field. Madhu is 15 millards. I saw them inside my basti, moving hither and thither. All accused were present in our sahi. Accused belonging to Bodasara sahi were damaging and demolishing houses. And to a query to the court as to other accused persons of Sabarna sahi and Kachara were present and demolishing the houses or not, answer is yes. He says then, my wife and children were standing outside at a distance of 40 to 50 feet from my house when the accused were demolishing my house. Some of my villagers were present at a distance of 20 to 25 cubits when my house was being demolished. Those persons were standing, concealing their presence. They had concealed their presence in the backside where there were trees. I was not assaulted as the house of Pandari. I had not gone up to the house of Pandari. I had not run away when I was assaulted. In between my house and that of Pandari, these accused were present. To my knowledge, there was dispute between the accused of Bodasara Sai and deceased Jadumani regarding lease of land. Jadumani had also obtained a piece of land on lease. I was given a blow by means of a lathi. There was no further assault. 10 to 12 persons had concealed their presence in the house of Pandari. Those who had kept themselves concealed in the house of Pandari went to his backyard, sat near the mango tree. I cannot say which of the accused named by me assaulted on which part of the body of Jadumani. Jadu was assaulted on the land of Padmanabh. Land of Padmanabh is about 50 to 60 feet from my house. Land of Padmanabh may be at a distance of 500 to 600 yards from my land. My land is also about 500 to 600 yards from my house. I have witnessed the entire incident about which I have deposed, sitting near my house. It's not a fact that I have not stated before police that accused specifically named by me in the chief chased deceased to the land of Padmanabh. It's not a fact that I have not stated before police that accused Vidyadhar told the other accused to come to the house of Pandari, saying that Jadumani has concealed his presence there. Land of Padmanabh is on the front side of the house of Pandari. It's not a fact that I have not stated before police that other accused whom I have not named specifically also chased deceased Jadumani. It's not a fact that I have not been assaulted by Niranjan and my house has not been demolished by the accused. Not a fact that I am deposing falsely in this case. Now, this is the evidence on which the reliance has been placed by the learned trial court to convict the appellants who are before your lordships, while acquitting the others who face trial along with them. Now, while acquitting the other co-accused persons, The court
in chief examination also, so far as the assault to the deceased is concerned, also he stated only the names of these 7 appellants.
Yes.
And what weapons they were holding, but not stated about anything about specific overtact of the appellants who part the assaulted.
For this reason, because all these 3 PWs have spoken consistently the names of these 7 appellants, these 7 have been convicted, and the other appellant Tikki, who was named by PW 15, he having not been spoken of as one of the assailants by PWs 1 and 6,
Tikki Naik.
he has been acquitted.
Tikki Naik.
Yes. Now, my lords, so far as the charges are concerned, your lordship will find that there was a specific charge under 302 against these appellants. Besides that, they were also charged under 302 read with 149. Now, along with these appellants, there were 57 others, my lords, against whom charges were also filed. Of these 57 accused persons, my lords, 3 accused persons are important for our purpose, my lords. They are acquitted accused persons Tikki Naik, Bhagavan Behera, and Muli Naik. Now, why Tikki Naik is important? Tikki Naik is named by PW 15 as one of the specific assailants of the deceased. And he was also charged along with these 7 under section 302 simpliciter also.
Tikki Naik name has only been stated by
PW 15.
No, PW 15. Not
And
by the
no,
1 and
not by 1 and 6.
8.
For that reason, my lords,
Tikki
has been acquitted.
Right.
Now, I only want your lordship to remember that Tikki was also charged separately under 302, just as these appellants. Then, my lords, the other acquitted accused who is important is Bhagavan Behera. Bhagavan is the chap who is said to have climbed up the thatch of
Bhagavan or Vidyadhar?
Bhagavan?
No.
Vidyadhar.
Vidyadhar.
Yes.
Vidyadhar climbed the roof.
Roof of the
that is Vidyadhar.
I am sorry, Vidyadhar. Now, Vidyadhar had climbed up the roof, made a hole, seen these people there, Jadumani and others, and called the villain. That part has also been disbelieved. He has been acquitted. Now, Muli is one of the accused persons, acquitted accused persons, from whom, my lords, the Gupti was seized. MO1. According to the PW 8, my lords, injuries 2, 3, 4, 5, 7, and 8 could have been caused by Gupti. Now, besides these 3 eyewitnesses, who specifically name these 7 appellants who are before your lordships, there are other eyewitnesses to the incident also. And these witnesses are PW2 Panu, PW3 Pondari, PW4 Budhei, who is also an injured, PW5 Surendra, PW7 Kulamani, PW10 Basanti, PW11 Chaitanya, PW12 Prafulla, PW13 Mathura.
Just a minute.
And PW19 also. Now, out of these witnesses, my lords, PW10.
Mr. Panda, are they witnesses to the assault on the deceased?
Lord, there.
Because the occurrence has taken place.
Occurrence has taken place in one go, my lords, and in the occurrence.
It is on 3 days. One is that about the comment,
Yes.
then that
Village meeting.
then
Yes, I am speaking of the 24th meeting. I am speaking of the 24th.
24th also phase by phase जो demolition एक last
गोटे year the morning hours there. So all these witnesses, they don't speak of the assault on the deceased.
Right, yeah.
They also don't speak about the presence of these witnesses, 1, 6 and 15 millards, as having seen the assault. Now the trial court millards, when he convicts, on what basis does he convict? He has convicted in his judgment, your lordship may kindly see, paragraph 25 millards, page 35 of the paper book. I'm sorry, page 24, para 24, page 34. Careful consideration of the oral evidence adduced on behalf of the prosecution. I am of the firm conviction that prosecution has not been able to establish charge under 302 by 149 IPC against accused except Dinabandhu, Rajkishore, Gauranga, Tikkina, Sridhara, Madhava and Gagana. And he has therefore convicted these persons under 302 read with 149. Now, before doing so, millards, kindly see paragraph 19 at page 29. Your lordship may kindly look at page 27 first. Para 16. Thus, from the discussions above, it is seen that the evidence of PWs 1, 6 and 15 to the effect that on the date of occurrence accused Raja, Dinabandhu, Tikkina, Gauranga, Sridhara, Madhava and Gagana, armed with lathi, farsak, panta and bhali, etc., murdered deceased Jadumani over the land of Padmanabha is clear and convincing. I do not find any reason to discard their evidence on this score. On the other hand, evidence of these three witnesses also finds support from eyewitnesses referred to above. Now, there is no eyewitness, millards, who has corroborated the evidence of these three persons. The other aspect, millards, what the court has said is at page 30 of the paper book. Page 30 of the paper book, at the last part, millards, of that page, 4 lines from the bottom. After discussing about interested witnesses and related witnesses, the court's finding is, in view of the principles laid down in the above reported cases, keeping in view the unassailed testimony of PWs 1, 6 and 15, which finds support from other witnesses referred to above, I have no other option save to conclude that on the date of occurrence accused, these appellants are named, forming an unlawful assembly, armed with deadly weapons, murdered deceased Jadumani in prosecution of their common object. Another intrinsic circumstance against these 7 accused is that their names find place as principal assailants in the FIR lodged at the spot within an hour of the occurrence, which rules out the possibility of any false implication of these accused at that stage. So, version of these 3 witnesses and the fact that they are named in the FIR. Now, if this is the evidence on the basis of which we have been convicted, that is the evidence of PWs 1, 6 and 15, Would your lordship kindly now look at the 313 statement?
ସବୁ ମିଛ ଜାଣେ ନା ମିଛ
ନା ମୁଁ କହୁଛି 313 page 97 ଟାକୁ ଆଜି ଦେଖନ୍ତୁ ଦିନ ବନ୍ଧୁ।
ସବୁ ମିଛ ସବୁ ଜାଣେ ନା
ନାଇଁ କ୍ୱେଶ୍ଚେନ୍ ଗୁଡାକ ଯୋଉ ଦେଖ ପ୍ରଥମ କ୍ୱେଶ୍ଚେନ୍ ହେଲା ଯେ ଭିଡିଓ ଶୋ ସେକେଣ୍ଡ କ୍ୱେଶ୍ଚେନ୍ ହେଲା ଭିଲେଜ ମିଟିଂ ଉପରେ ଥାର୍ଡ କ୍ୱେଶ୍ଚେନ୍ ହେଲା ଦି ହାଉସ ଅଫ ଡିସିଜ ଯଦୁମଣି and his younger brother was pelted with brickbats ସେ ବି ଭିଲେଜ ମିଟିଂ ପରେ fourth question ହେଲା enmity between the parties on account of lease fifth question ହେଲା that you along with other accused were members of an unlawful assembly in the hamlet called Jemavanta Sahi at about 8 a.m. on 24/8/94, common object of which was to ransack and damage the houses of members of the prosecution party of Sano Sahara Sahi and to cause death of Jadumani and to assault other inhabitants of the said hamlet. Now, this question number 5 has been put not only to these appellants, it has been put also to the other acquitted appellant, accused persons also. Next question is, it transpires from the evidence that members of the said unlawful assembly, of which you were a member, were armed with deadly weapons like bhalli, kamta, farsa, koturi, gupti, etc. What have you got to say? Answer is no. Then, the three material questions, my lords, relating to these three which have also been put to the other accused is, question 7, transpires from the evidence that the members of the said unlawful assembly, of which you were a member, in prosecution of the common object, ransacked and damaged the houses of deceased Jadumani Behera, Jhuni Behera, PW1, wife of Chabi Naik, Panu Parida, PW2, Pondari Naik, PW3, Budhei Dei, PW4, wife of Chaitan Naik, and Ramesh Naik, PW6, Puramani Behera 7, Chaitan Naik, PW11, etc., by way of raising the thatch and wall to the ground and cutting green trees. What have you got to say? The next question is, it transpires from evidence that this is Jadumani of Sano Saurasai was done to death when he was brutally assaulted on the land of one Padmalabh Sahu with deadly weapons by you and accused so and so, so and so, so and so. He names the other appellants, including the acquitted appellant Tikinai, in prosecution of the common object of the said unlawful assembly of which you are a member. What have you got to say? Answer is Micha. Further transpires from the evidence that you, along with other accused, surrounded deceased Jadumani on the land of Padmanabha when he was brutally assaulted by you, the above named accused persons named in question number 8. What have you got to say? Where has the evidence of PWs 1, 15 and 6 been put to the appellant? And the CE report is that neither MO2 nor MO1 bloodstains were found. And then your lordship may also see the spot map. The clinching feature in the judgment is paragraph 14. Page 26 of the paper. How the court comes to a conclusion that injury number 9 must have been caused. Replace that paragraph.
Yes.
Thus, from the evidence of PWs 1, 6, and 15, it is seen that on the date of occurrence, accused, these appellants are named, being armed with deadly weapons like Konta, Farsa, Koturi, Tangia, and Lathi, assaulted deceased over the land of Padmanabh, and in consequence of that, Jadumani died at the spot. Evidence of these witnesses regarding implication of Niranjana as stated by PW1 and Tikki as stated by PW15 being inconsistent, they are entitled to the benefit of the doubt. It is contended by learned defense counsel that evidence of these witnesses shows that all these accused were armed with sharp cutting weapons. But injury number 9, as revealed from evidence of PW8, is a lacerated injury. But none of these witnesses has stated how this lacerated injury was caused, which, as per postmortem report, is the cause of death of the deceased. In the above background, it is asked that the charge under 302 read with 149 IPC has not been established by prosecution against these accused persons. But as discussed above, PW 6 and 15 have categorically stated that some of the accused persons were also armed with lathi. And in such circumstance, possibility that injury number 9 must have been caused by the same lathi cannot be ruled out. In addition to that, the doctor in para 7 of his evidence has stated that the IO has also sent a Koturi and a Gupti for his opinion, and after examining the same as per Exhibit 15, he replied that injury numbers 1, 4, and 9 could be caused by Koturi, and the rest external injuries could be caused by a knife. There is nothing in the evidence of the doctor to suggest that the opinion given by him as per Exhibit 15 is not correct. In the above background, I do not find any force in the contention of learned counsel that prosecution has not been able to establish how injury 9 was possible, which is the prime cause of death of the deceased. It is next contended by learned defense counsel that injury 9 is undoubtedly due to an accidental fall as admitted by the complainant himself. In para 7 of the cross-examination of PW 15, it is seen that the complainant has admitted that while running, deceased Jadumani fell down on the land of Padmanabha and he was not assaulted by any one of the accused before he fell down. In the premises, it is suggested to him that deceased died due to fall on the land of Padmanabha. No one had assaulted deceased there. Such a suggestion appears to be without basis. If none of the accused has assaulted deceased over the land of Padmanabha, it is not known how other 8 external injuries were noticed on the body of the deceased during postmortem, which are antemortem. And therefore, the court has concluded that the evidence of PWs 1, 6, and 15 to the effect that these appellants have committed the murder is believable and it finds support from the eyewitnesses. So, who are the other eyewitnesses who support?
Mr. Panda, you made a submission that in the accused statement of the 7, 7-1 is dead. The evidence of these 3 eyewitnesses, 1, 6, and 15, have not been paid. But if you come to we are just showing you that you come to paper book page number 47. That is the accused statement of Dinabandhu Devuri. That is appellant number 1. And what the learned trial court has done, we come to question number 24.
Yes.
It transferred from the evidence
that you along with Tikina, Tikki, Gauranga, Rajkishore, and Madhava and other accused persons chased, overtook, and overpowered him on the land of Padmanabha South. What have you got to say?
Next question.
It transpires from the evidence that you were armed with a koturi at the time of occurrence. What have you got to say?
Yeah.
That you assaulted deceased to his right upper arm by means of the koturi. What have you got to say?
That is how to the other, we have verified it. That is how even the other appellants also put that in gist. But you are right that individually, Sankara Semanakara, you evidence put Khali adhire nahi kono, it transpires from the evidence of PW, you eyewitness,
evidence incriminating.
যে এই কোয়েশ্চেন গুড়াকর যে আনসর গুড়াক মু দেইছি এই আনসর গুড়াক দে আর নাইদার ইনক্রিমিনেটিং টু মি nor these questions satisfy the requirement of three.
No, how can it that you were armed with koturi, Micho.
I was assaulted with a koturi.
You were assaulted by means of koturi on the right upper arm.
Mo gharu jo recovery heichi koturi. Se koturi ta ye blood stains.
That is a different the submission you made that if we have followed your argument correctly, that the evidence of the 3 eyewitnesses have not been put to the specifically not put. But in gist, whatever they have stated, that is put that land re hela apan emanok soityo thile apan mane taku chase gale overpower kale tapare apan ei weapon dhartile apan ei weapon re ei jaga ku marle emti achi kebol nahi kono
ତାଙ୍କର ସ୍ପେସିଫିକ ନାଁ ନାହିଁ କି ଏଇ ଆକ୍ୟୁଜ କହିଥା ତେଣୁ ମତେ ଯଦି ସେଇଟା ପଚରା ହେଇଥାନ୍ତା ଆଜ୍ଞା ମୁଁ ସିନା ଉତ୍ତରଟାକୁ କହିଥାନ୍ତି କଣ ପାଇଁ ସିଏ କହିଛନ୍ତି ଧରିକିରି ତାଙ୍କ ନାଁ ଗୁଡାକ କହିଥିଲେ କାହିଁକି ଗୁଡାକ ଆଇ ଉଡ୍ ହାଭ୍ ଆନ୍ସର୍ଡ ବଟ୍ ସ୍ପେସିଫିକାଲି when that has not been put Millers, my submission is how do I know that on what evidence the court is asking these questions?
लाइन स्टार्ट होची इट फर्दर ट्रांसफर माने आगुरु तो कुआ जाई से जो एविडेंस गुडा के एठी एटा गोटे जस्ट हमें देखे ता पूर्वरु से कहउचंदी रेफरिंग टू द विटनेस एटी गुडा हसिला जे फर्दर ट्रांसफर ऑफ द एविडेंस दैट ए माने या कले ता संगे ଆପଣ ଥିଲେ ଚେସ୍ କଲେ ଓଭର ପାୱାର କଲେ
ହୁଁ।
ୟା ଜମିରେ କଲେ ଆପଣ ଏଇଆ ଧରିଥିଲେ ଆପଣ ଏଇଥିରେ ଏଇ ଜାଗାକୁ ମାରିଲେ
ଆଜ୍ଞା।
ଠିକ ସେଇ ଟାଇପ ର ମଧ୍ୟ ଏକ୍ଜାକ୍ଟଲି ଆସିଛି ଯିଏ ଯୋଉ ୱେପନ ଧରିଥିଲା ଅନ୍ୟ ଏଭିଡେନ୍ସ ମଧ୍ୟ ଆସିଛି ୟୁ ଆର୍ ରାଇଟ୍ ଦ୍ୟାଟ୍ ଏଇ ଯୋଉ ତିନିଟା ୱିଟନେସ୍
Specifically କରାହେଇଛି।
ସ୍ପେସିଫିକାଲି କୁହା
is your finding that a trial court that it might have been by a lathi because the witnesses have said and that is the basis of the conviction.
ନାଇଁ ଲାଠି ଇନଫ୍ୟାକ୍ଟ ଏଇ ଯୋଉ ଆପଣ ଯଦି ଦେଖିବେ ଏଇ 7 ଜଣଙ୍କୁ ଯୋଉମାନଙ୍କୁ କନଭିକ୍ସନ ହେଲା
ଆଜ୍ଞା
ତାଙ୍କ ଭିତରୁ ଇଫ ୟୁ କମ୍ ଟୁ ଦି କାରଣ ଜଣେ ହିଁ କହୁଛି 2 ଜଣ ବୋଧେ ଇଫ ୟୁ କମ୍ ଟୁ PW1
ଆଜ୍ଞା
କିଏ କୋଉ ୱେପନ ଧରିଥିଲା ସେ ସବୁ ଗୁଡାକ କହୁଛି ତା ଦେହରୁ
ସିଏ କହିଲା ପରା paragraph 6 ରେ କହିଲା paragraph 5 ରେ
5 ରେ କହିଲା
ଆଜ୍ଞା Raja was armed with a farsa.
ହୁଁ
Dinabandhu was holding a katari. Gagan was armed with a kanta. Tikkan was armed with a tangia. Sridhar was armed with a koturi. Madhava was armed with a farsa. Gauranga was armed with a farsa. All other accused persons were also armed with lathi, thenga and deadly weapons. And se କହୁଛନ୍ତି ଯେ ଅନ୍ୟମାନେ ତାଙ୍କ ଛଡା
ତାପରେ
Next
ନେକ୍ସଟ ପାରାଟା ହଉଛି important
next specific କହିଲେ Raja attacked the right side shoulder of my elder father by a farsa. Dinabandhu assaulted my elder father to his right hand upper arm by a koturi. Tikkan dealt blows by means of a tangia to the right leg of my elder father. Thereafter, other accused whom I have named above, ଯୋଉମାନଙ୍କୁ ମୁଁ କହିଛି ଯୋଉମାନଙ୍କ ନାଁ କହିଛି also mounted attack on my elder father with the weapon of offences with which they were armed with. ତେଣୁ ଯୋଉମାନଙ୍କ ନାଁ କୁହାଯାଇଛି କେହି ଆଜ୍ଞା ଲାଠି ଧରିନାହାନ୍ତି
ନାଇଁ ସେ ତ ସେ ହିଁ କହୁଛି ତେଣୁ ଯୋଉମାନେ ଯୋଉମାନଙ୍କର ନାଁ କହିଛି ତାଙ୍କ ଭିତରୁ କେହି ଲାଠି ଧରିନାହାନ୍ତି
ନା
ୟୁ ଆର୍ ରାଇଟ୍ ତେଣୁ ବଟ୍ ଦିଜ୍ ୱେପନ୍ସ ଭିତରୁ ଗୋଟେ ୱେପନ ସେ କଟାରୀ ଦ୍ଵାରା ହେଇପାରିବ ବୋଲି ଡାକ୍ତର କହୁଛନ୍ତି ବାକି ଯୋଉ ଆମେ ଟାଙ୍ଗିଆ ଆଉ ଫାର୍ସା ଯାହାର ଗୋଟେ ଇଏ ହୋଲ୍ଡ ମାନେ ଗୋଟେ ବ୍ଲଣ୍ଟ ସାଇଡ୍ ଆଉ ଗୋଟେ ସାର୍ପ ସାଇଡ୍ ଥାଏ ସେଇଟା ଆଡମିଟେଡଲି ସିଜର ହିଁ ହେଇନି
ଆମେ କଣ ଆଜ୍ଞା ସେଇଟାକୁ ଧରି can we come to a conclusion that it might have been done this way?
नो क्वेश्चन ହଉଛି ଯେ ସେଇ ଆପଣ ଯୋଉ କହୁଛନ୍ତି ନା ଯୋଉମାନେ ଅନ୍ୟମାନେ ଅଛନ୍ତି ଲାଠି ଧରିଥିଲେ ତାଙ୍କରି ଭିତରୁ ହୁଏତ ସେ ଫାଟାଲ ବ୍ଲୋଟାକୁ କିଏ ଦେଇଥିବ it is not given by is it your contention like that
my contention is this that the finding which the learned trial court has said that because there is evidence that some of them were holding lathis the blow injury number 9 can be caused said to have been caused by it. Can that be sufficient to convict these appellants for the offense under 302 read with 140? ये जो paragraph 14 रे जो कोर्ट ऑब्जर्व करले तांका जजमेंट रे para 14 page 26 First, he has dealt with the contention of the defense, subparatai. The sentence begins, it is contended by learned defense that evidence of these witnesses show that all these accused were armed with sharp-cutting weapons. But injury number 9, as reveals from evidence of PW8, is a lacerated injury. But none of these witnesses has stated how the lacerated injury was caused. Which, as per postmortem report, is cause of death of the deceased. In the above background, it is urged that the charge under 302 read with 149 IPC has not been established by prosecution against these accused. But as discussed above, PW 6 and 15 have categorically stated that some of the accused are also armed with lathi. In such circumstances, possibility that injury 9 must have been caused by the same lathi cannot be ruled out. And then he says that the doctor at para 7 has stated that the IO sent a Koturi and a Gupti for opinion. He replied that injuries 1, 6 and 9 could be caused by Koturi. Rest external injuries could be caused by a knife. And because there is no suggestion to the doctor that the opinion is not correct, there is no force to accept the contention of the defense counsel that prosecution has not been able to establish how injury 9 was possible. Now, can this be the basis on which our conviction can be sustained?
No.
No, that is the only ground on which it was.
No, that is not. See, মানে এই ଯୋଉ ଲାଇନଟା କହୁଛନ୍ତି ନା ଯୋଉ sharp cutting weapon ଥିଲା ତେଣୁ ତା ଦେହରୁ କିଛି accused person some of the ମାନେ which obviously excludes
these appellants
ତେଣୁ ସେମାନଙ୍କ ଭିତରୁ ଇଏ ଯୋଉ ଲାଠି ଧରିଥିଲେ ହୁଏତ ତାଙ୍କ ଭିତରୁ this let us say this finding is not correct. This is an error of record. Let us say କାରଣ ଅନ୍ୟମାନେ ଯୋଉମାନେ ଲାଠି ଧରିଥିଲେ ତାଙ୍କ ଭିତରୁ କେହି deceased କୁ ମାରିବା କଥା none of the eyewitnesses have stated. But again he has stated that ଗୋଟେ weapon ଏମିତି ଅଛି like କଟୁରୀ ଯୋଉଟା କି ଡକ୍ଟର କହୁଛି ତା ଦ୍ୱାରା ମଧ୍ୟ ସେ lacerated wound ହୋଇପାରିବ. In addition to that, he has not taken into account that some of the weapons, if it is used from the blunt side also, that is the evidence of the ସେ ଯୋଉ ଆପଣଙ୍କର ଯୋଉ weapon ତେଣୁ ସେଇଟାକୁ ସେ ନେଇନି କିନ୍ତୁ ଏଇ ଲାଇନଟା you are right that ଟ୍ରାଏଲ କୋର୍ଟର ଯୋଉ ଏଇ ଯୋଉ ଲାଇନଟା ଲେଖିଲେ ଯେ ଯୋଉମାନେ ତାଙ୍କ ଭିତରୁ କିଛି ଲାଠି ଧରିଥିଲେ ସେମାନେ ହୁଏତ ମାରିଥିବେ ଯୋଉଥିରେ ଇଞ୍ଜୁରୀ ନମ୍ବର 9 possible ହେଇଥିବ that is obviously an error of record କାରଣ ଏଇ 7 को ଛାଡ଼ିଦେଲେ ଆଉ କେହି deceased କୁ ମାନେ ସେ ଯୋଉ ସେ ଜମି ଉପରେ ମାରିବା ଏ କଥା ଆଟଲିଷ୍ଟ 3 ଜଣଙ୍କ ଆଇ ୱିଟନେସ ରେ ନାହିଁ.
The evidence that he doctor ଟିକେ ଆଉ ଥରେ ମୁଁ ପ୍ଲେସ୍
ଦେଖୁନାହାନ୍ତି
page 408
ଡାକ୍ତରଙ୍କ ପାଖରେ ଦୁଇଟି ମାତ୍ର ୱେପନ ପ୍ରଡ୍ୟୁସ ହେଇଛି ମୋଷ୍ଟ ଲାଇକଲି ବୋଧେ ଅନ୍ୟ ଗୁଡାକ ସିଜ୍ ହେଇପାରିନି
ସିଜ୍ ହେଇନି ସିଜ୍ ହେଇନି
ହଁ ନାଇଁ ମୁଁ ସେଇଆ କହୁଛି ତ ଯେ ଯୋଉ ଏଇ ଦିଟା ୱେପନ ସିଜ୍ ହେଇଛି ସେଇ ଦିଟା ହିଁ ପ୍ରଡ୍ୟୁସ ହେଇଛି that doctor is PW 8
page 408 my lords may look at his cross exam
ସେ cross examination ପଳେଇ
କହିଲେ external injury numbers 1 to 8 are incised wounds parana. Incised wounds will have length, breadth as well as depth. In case of external injury number 5, 7 and 8, depth of the injuries were skin deep. Superficial wounds. In case of external injury number 6, the bone was affected. Bone injury on humerus and on metacarpal bone were visible externally. 6 is of forearm, which is attributed to Dinabandhu. এই জায়গায় ইনজুরি হয়েছে তেমন সেটা ভিজিবল ফ্র্যাকচার I did not require any dissection to know that there was underlying bone injuries at those places. I have not dissected injuries numbers 1 to 6. Injuries 1 and 6 were determined to be fracture injuries by simple touch and movement of the affected parts. Since it was a case of postmortem, X-ray examination was not conducted.
ମାନେ obviously କେତେ ଗୁଡା injury ଜଣା ପଡିଯିବ ମାନେ
ତେଣୁ ତାପରେ କହିଲେ a lacerated injury is always the result of a hard and blunt substance. Injury on the left frontal region has caused laceration to the brain matter, tearing of dura, pia and arachnoid. It is not a fact that
you line Mr. Pandya and you also check it. ବୋଧେ ମୋଦି ଜୁରିସ୍ପ୍ରୁଡେନ୍ସ ଅଛି ଆପଣ ସାର୍ପ କଟିଂ ୱେପନ ରେ ସାର୍ପ ସାଇଜ ୟୁଜ କରିବେ ଗୋଟେ ଏମିତି ଗୋଟେ ଜାଗାକୁ ମାରିବେ ଯୋଉଠି କି ହାଡ ରହିଛି
ସ୍କାଲ୍ପ ଉପରେ it may take the shape of a laceration.
It's not that ସେ ଜାଗାରେ ଆପଣଙ୍କର ଇଏ ହବ.
Yes.
ବୁଝିଲେ ଯଦି ମାଂସ ଥିବ
I have noted that in Modi.
ମାଂସ ଯଦି ଥିବ ସେ ଜାଗାରେ ଇଏ ହେଲେ ସାର ଆସିବ କିନ୍ତୁ ହାଡରେ ଯଦି ବାଜିଲା ସେଟା lacerated wound ହବ.
It will look like a lacerated
wound, but it will be caused by a sharp cutting in its sharp side. Modi jurisprudence, clear.
Yes, clear. I don't dispute that. Then the doctor says, it is not a fact that I have not mentioned in Exhibit 14 that injury 9 corresponds to laceration of brain matter and tearing of dura, pia and arachnoid. Para 11 re specifically se कहले sharp edge of MO2 was not used to cause injury number 9. So we can eliminate Miller's that we cannot even import the thought that it could have been caused by the blunt edge. Chapter 12 it is a fact that I have not mentioned in Exhibit 14 that the death of the deceased was due to shock and cumulative effect of all the injuries. On a postmortem report, he has admitted that death is, he has not mentioned that death was due to cumulative effect of all the injuries. It is possible that the brain material could be lacerated without fracture of the scalp bone. It is not possible that there could be laceration to brain material without a head injury. There cannot be laceration to the brain material unless the head comes in contact with a hard substance. I have just mentioned in Exhibit 14 that cause of death was due to laceration to the brain matter. Now, what is the import of this answer? The import of this answer is that even without fracture of the scalp bone, laceration of the brain is possible. This is what he is admitting. But he says that without a head injury, a laceration of the brain is not possible. So there has to be a corresponding external injury on the head without a fracture also. Then again he says that no laceration to the brain material is possible unless the head comes in contact with a hard substance. So what is a hard substance has not been elaborated by him, Millers. And he has simply said that I have just mentioned in Exhibit 14 that the cause of death was due to laceration to the brain matter. So therefore, the next answer to my next question assumes importance. External injury number 9 could be caused by a fall. Counsel put that question, my lords, to the doctor because of the evidence of PW 15 that while running, Jadumani fell down on the field of Padmanabh. And before falling down, he had not been assaulted. Now, if the medical evidence is this, that the external injury number 9 could be caused by a fall, if the medical evidence is that the lacerated injury number 9 was possible without fracture of the scalp bone, which is admitted, and if the postmortem report rules out that the cause of death was due to shock and the cumulative effect of all the injuries, my respectful submission, my lord, says that the conviction under 302 read with 149 cannot be held. And we are considering, my lords, things as a whole. If we are considering things as a whole, now what is the initial case? That the acquitted accused, Vidyadhara, who climbed up the roof of Pondari, made a hole in the roof, saw these people inside, and said that yes, these people are here for which we chase them, Miller. That aspect has been disbelieved.
No, that aspect,
Vidyadhara chadi, kona kari, ଦେଖିକିରି କହିଲା
ବିଦ୍ୟାଧର ଏଭିଡେନ୍ସ ଟାର ସମସ୍ତଙ୍କର କନସିଷ୍ଟେନ୍ସି ନଥିଲା ବୋଲି
ଯଦି ଆଜ୍ଞା ସମସ୍ତଙ୍କର କନସିଷ୍ଟେନ୍ସି is the thing that we are going to see, Millers. Then consistency has to be seen also of these three witnesses. ଏ ତିନି ଜଣଙ୍କର କନସିଷ୍ଟେନ୍ସି ଯଦି ଆମେ ଦେଖିବା, ଏ ତିନି ଜଣଙ୍କ କନସିଷ୍ଟେନ୍ସିରେ PW1 ଆଜ୍ଞା ପ୍ରଥମ କଥା ଇଞ୍ଜୁରି ନମ୍ବର 9 ଟାକୁ ଯୋଉ ଦେଖିଲା ବୋଲି କହୁଛନ୍ତି Depose kala beloku has not spoken about it initially. She admits and it has been confronted to the IO, who also says that she has not stated before me to have seen injury number 9. ତାପରେ ଆଜ୍ଞା ସିଏ ଯଦି ଆମ୍ବ ଗଛ ମୂଳରୁ ଥାଇକିରି 120 ଫୁଟ ଦୂରରେ ଇନସିଡେଣ୍ଟ ଟାକୁ ଦେଖିଲା, ଇଏ 7 ଜଣ ସରାଉଣ୍ଡ କରିଛନ୍ତି, अन्य साक्षी मैंने कहते ये 7 जन छड़ा अन्य माने भी चेज करचंती ताले स्पेसिफिकली आज्ञा हाउ कैन सी एट्रीब्यूट इंजुरीज टू ऑल दीज पीपल that these people are the authors of these injuries जदि ये 4 जन आज्ञा ये 7 जन जदि इंज्योर करचंती असॉल्ट करिकी अन्य माने आज्ञा मध्य तांको पछरे गोडीकिरी जाईचंती सेमान को जदि खलास करा गला एमान को को बेसिस रे आज्ञा तांको सेग्रीगेट कराई किरी कन्विक्ट कराबो And who is she? Is she an independent witness? No. She is the daughter of the informant miller.
Niece of the
Belongs to the same family, milords. She has an interest in the prosecution story, milords, in seeing these people convicted. Because one of these appellants is said to have made a comment to her cousin. If we take things in a totality, milords, it becomes impossible, milords, that you can pick and choose and convict these people only. And a separate charge 302 re kahi heitala because of this evidence in the 161 statement probably. Ei tinta kaichan theri ki je mane hanichanti boli. Specific charge under 302 ta to establish hi parlan na evidence at the trial re. If specific evidence at the trial could not be led to show that these appellants are liable or culpable to have committed an offense under 302, the mere fact that they stood charged under 302 read with 149, can it be done only on the basis of this evidence, milords? And when PW1 and PW1 herself says that PW15 could not have seen the occurrence. Juni Behra Prakaichi, my father had confined himself inside the house of Mongoli when my elder father was assaulted on the land of Padmanabh. Para 10 रे आज्ञा जूनी बेहरा रो स्टेटमेंट होची ते मो बापा देखि नांती घटना आज्ञा जदि सी देखि नांती घटना ताले PW15 को देखंतु 15 कोन कहिसंती 15 कहले पेज 435 रे
बारंडा देखला
ନାଇଁ ନାଇଁ 15 ଘଣ୍ଟା ବୋଲି କହିନେ ସେ 15 ପୁରା ଇଏ
15
ମଙ୍ଗୁଳି ବାଡିରେ ଥାଇକି ସେ ଦେଖ ଯୋଉ ତାକୁ ବାଡେଇକି ଯୋଉ ଚେସ୍ କଲା
କହୁଛି କଣ
ମାଡ ହେଲା ସେଟା
he was assaulted by accused Brindavan paragraph 6 page 435 ଦେଖନ୍ତୁ page 435 I was assaulted by accused Brindavana and Gauranga by means of brickbats. I sustained bleeding injury in my both legs. So I could not go out to rescue my brother. I got stuck up in the valley of Monguli because of the assault on me.
जोटा की झियो को
अन्य माने देखि नाही
झियो कोची तारो जे सीता
घरे रहिगला
आगे सी जो कहूची that the land of Padmanabha was clearly visible to me from the valley of Monguli. The spot map itself, my lord, shows that it is not possible. Monguli रा house tag देखंतु serial number 3 in the spot map. Number 3, Mongoli's house is number 3.
Code is spot map कोथरे
Spot map is
464.
464.
এটা মঙ্গলি it is spot ସେ କହୁଛି
କୋଟା ପ୍ୟାଡି ଫିଲ୍ଡ ଅଫ ଇରାଜା
ପ୍ୟାଡି ଫିଲ୍ଡ ଟା ଏଠି ଦେଖଉଛି ନମ୍ବର 1 ହେଲା ହାଉସ ଅଫ ପନ୍ଦାରି ଯୋଉଠୁ ଦୌଡ଼ିଲା ନମ୍ବର 3 ହେଲା ହାଉସ ଅଫ ମଙ୍ଗୁଳି
ନାଇଁ ନାଇଁ
ପଛକୁ
ମଙ୍ଗୁଳି ଟା ପଛକୁ ଅଛି ବୋଧେ ମଙ୍ଗୁଳି ବେହେରା ସେ ଯୋଉ ହାଉସ ଅଫ ସେପାରେଟ ଦେଖା ହେଇଛି
ନାଇଁ ମଙ୍ଗୁଳି ନାୟକ ପରେ
ମଙ୍ଗୁଳି ନାୟକ ତାର 3 ନମ୍ବର
ଆଜ୍ଞା ଯଦି ୟା ବାଡିରେ ଆଜ୍ଞା ସେ ରହିଲା ସେ କେମିତି ଏଟାକୁ ଦେଖିବ
କୋଉଠି କଣ ସେମିତି କିଛି ପଚରା ହେଇଛି ପଚରା ହେଇଛି
Unless you bring it, how can we
ସେମିତି
say
how
at this
can we
stage?
imagine?
It was an open area, whether he moved to the other side.
ଗୋଟେ ଆମେ ସିନା ଆଜ୍ଞା ପ୍ରିଜ୍ୟୁମ କରୁଛେ ବା ଆମ୍ବ ଗଛ ବି ଦେଖେନି ଯୋଉ ଆମ୍ବ ଗଛ ପାଖରେ ଛିଡା ହେଇକି
ଆପଣ ତ କ୍ରସ୍ ସେନ୍ସର ସେଟା ଅଛି ପୁରା ଯେ ଆସିଛି ଇଏ ଅଛି ବୋଲିକିରି କ୍ରସ୍ ସେନ୍ସର ଆସିଲା ଟ୍ରି ଅଛି ବୋଲିକି ପାଖରେ
ଏଇ ଯୋଉ
କଣ ଆସିଲା କ୍ରସ୍ ସେନ୍ସର ଟ୍ରି ଆସିବ
ଅଛି
ଟ୍ରି ଅଛି ପାଖରେ ହଁ।
ତେଣୁ ଯଦି ଝିଅ କହୁଛି ମୋ ବାପା ଦେଖିନାହିଁ ତାହେଲେ ବାପକୁ ଆମେ କେମିତି ବିଶ୍ୱାସ କରିବା? PW6 is a person who was present in the village. He is examined 6 days after.
PM report रे अवश्य you are right that he से कहिछि जहा admit करछि मध्य केवल exclusively से attribute करछि injury number 9 ताकू cause of death, but in the chief examination perhaps he has stated that in addition to that injury number 9 all the injuries cumulative effect.
That is something which he has not stated in the PM report. এটা কইছি page 407 para 5. Cause of death is due to laceration of brain matter associated by multiple injuries
and associated
on different parts of the body as indicated above.
जोटाकू आपण क्रॉस एग्जामिनेशन आनिचंदी जे नाही तमे पीएम रे केवल कहिथिलो जे इंजुरी पीएम रिपोर्ट ता केते
exhibit 14
सेकंड पेज अछि opinion of death was due to the injury to the head causing laceration of the arm. Specific.
तापरे तांकर एडमिशन होती तरी that external injury number 9 can be caused by a fall. That also he agrees.
Mr. Nayak, you took note of this point. It's a very vital point. कारण ए 9 नंबर टाकू छाड़ी देले अन्य जो 8टा इंजुरी रही छी एगुडा कहूची सब नॉन वाइटल पार्ट ऑफ द बॉडी रे रही
सुपरफिशियल भी
तादर केतोडा सुपरफिशियल लाइक आर्म रे रही छी लेग रे रही छी और स्कैपुला राइट स्कैपुला रही ई गोटी ही इंजुरी जोटा की हेड राइट तो डॉक्टर मध्य स्पेसिफिक कहउचंती तांगर पीएम रिपोर्ट रे सेई जो हेड इंजुरी ही कॉज ऑफ डेथ एटी तब गोली दी जंती जोटा की से बाहर करी नानी चंती जे नहीं तमे येटा तो एमाने जो वेपन गुडा धरचंती एडमिटेडली दोज आर ऑल शार्प
कटारी एंड
हां कटारी ताकू से एक्सप्लेन करूचंती जे कटारी रे मध्य हेई परिबो किंतु ताकू क्रॉस एग्जामिनेशन में आनी चंती जे शार्प एज यूज हेनी माने कटारी रो MO2 टा होची कटारी तो MO2 टा कटारी MO2 शार्प साइड यूज हेनी बोली 11 क्वेश्चन नंबर 11 क्रॉस एग्जामिनेशन में बाहर करिया तेणु ऑब्वियसली जदि आपनकर एविडेंस आसी जाउची तेणु कोनोसी वेपन रो शार्प साइड यूज हेई जेनी बोली जना पड़ुची माने जहाँ ये करुची तेणु बाकी रहा जो लैसरेटेड वुंड गोटे फॉल देखौचंदी समाने जोटा कि आपनकर फिटनेस माने ये मध्य कहूची डॉक्टर मध्य कहूची से जो इंजुरी टा फॉल जो हेई परिबो जस्ट टेक नोट ऑफ इट इंजुरी नंबर सेटा हो 14 नंबर वेपन तेणु से इंजुरी टा को जदी फॉल को एट्रिब्यूट कर दवा जदी तांकर आर्गुमेंट होची सेटा जदी फॉल को नै जिबा बाकी इंजुरी टा जदी नॉन वाइटल बट बॉडी रे रहिला ताले वेदर ए कन्विक्शन अंडर 302 149 वुड बी मेंटेनेबल और नॉट लेट अस से जाईची फॉल हेची फॉल रे ए इंजुरी टा हेड इंजुरी टा रिसीव करची तापर जो माने असॉल्ट करचंती 7 जण अक्यूज्ड जस्ट थिंक ओवर इट 7 जण अक्यूज्ड घेरी किनी इफ ईच ऑफ देम was holding a sharp cutting weapon and they have caused only 8 injuries. That means कौनसी गोटी accused हुए तो रिपीट कर सही पारे बाकी के रिपीट भी करना जदि आपनकर समस्त जदि गोटी गोटी भी ब्लो देइतबे 7टा ब्लो ତେଣୁ ଗୋଟିଏ ମାତ୍ର ରିପିଟ୍ କରିଛି, ଆଉ କେହି ରିପିଟ୍ କରିନାହାନ୍ତି, and that too in the non-vital part of the body. ତେଣୁ whether it can be said that by causing these injuries, their intention was to commit murder. If we exclude that injury number, କାରଣ କେତେଗୁଡେ decisions ମଧ୍ୟ ଅଛି ଆପଣ ପାଇବେ that when number of accused persons assaulting the deceased and those are on the non-vital part of the body, only one injury is on the head is the cause of the death, and the prosecution is not specific as to who has caused that injury. Hala, ତେଣୁ ସେଠି 302(149) କୁ ସେମାନେ alter କରି 304 part 2 149 କରିଛନ୍ତି. There are good number of decisions, at least that
କିମ୍ବା ଯଦି ସ୍ପେସିଫିକ ଇଞ୍ଜୁରି ଗୁଡାକ ହବ 324 by 149
specific combined effect ରେ ଆସୁଛି ତ 304 part 2 ସେମାନେ କରିଛନ୍ତି ସେ injury ଗୁଡା. You see that those decisions you will get number, particularly in 1994 Supreme Court cases ଆଉ ଗୋଟେ ଅଛି 96 ରେ ଏଇ ଲାଇଟ୍ ରେ decisions ଗୁଡାକ ଅଛି ଯେ out of the ସେଠି varieties of ମାନେ ଗୋଟେ ର ତ ବୋଧେ 28ଟା injury ଥିଲା, ଆଉ ଗୋଟେ ଏମିତି only one injury is on the head and that is the cause of death, but the prosecution is not coming forward that who is the author of that. So the କାହିଁକି ସେମାନେ କଲେ reason ଦଉଛନ୍ତି ଯେ ଯେହେତୁ ଏଠି ଗୋଟେ number of persons were there, they were having sharp cutting weapons with them and they are not causing any assault on the vital part of the body. ତେଣୁ what would be its effect, whether their intention was to commit murder or to cause such injury which are likely to cause. Distinction ଆଣିକିନି ସେମାନେ କରିଛନ୍ତି, but see that injury whether in the factual scenario it can be differentiated or not. କାରଣ but ଏଠି admittedly ଦିଟା at least weapon ଯୋଉଡାକ ଯଦି blunt side use କରାଯାଇଥାନ୍ତା ହେଇଥାନ୍ତା, but that has not been seized. Like axe ଟା ଗୋଟେ ଟାଙ୍ଗିଆଟା ଆପଣଙ୍କର ଟାଙ୍ଗିଆର ଇଏ ରହିବ ନା, ଗୋଟେ ରହିବ କାଠ,
କଟାରୀର ମଧ୍ୟ ବ୍ୟାକ୍ ସାଇଡ୍ ଟା ମଧ୍ୟ
କଟାରୀ ତ ସେ କହିଛନ୍ତି, but we are holding, let us say that ଯୋଉଟା ଟାଙ୍ଗିଆ ଆପଣଙ୍କର ଦେଖିଥିବେ କାଠ ରହିଲା ତା ଆଗେ ରହିଲା ଏବଂ ଆଉ ଗୋଟେ କଣ ଫାର୍ସା ସେ ସେମିତି ଇଏ ରହିକିନି ତାର ସେ ୱେପନ ସିଜ୍ ହେଇନି। ତ ସେଠି obviously ତାର ଗୋଟେ ସାର୍ପ ସାଇଡ୍ ଆଉ ଗୋଟେ ବ୍ଲଣ୍ଟ ସାଇଡ୍ ରହୁଛି, ତେଣୁ another decision is there, I think it is 74 Supreme Court, that when the prosecution is telling that axe has been used, knife has been used, pottery has been used, it is to be presumed that sharp side has been used. If the prosecution says that the blunt side has been used, they are to say that the blunt side has, but generally it is to be presumed that it is sharp side. तमें खाली କହିଦେଲେ ହବନି ଯେ ସେ blunt side ହୁଏ ତ ହେଇଥିବ. So that is one line of decisions is there. Presumption ହବ ଯେ it is sharp side usage. ତେଣୁ ये लाइट रे गोटे रहुची आ गोटे रहुची ए जो number of injuries caused, one of the injury is the cause of death, that is on the vital part of the body, other all the injuries are on the non-vital part of the body. What would be the effect?
And the fall is in the paddy field again. You also see that. That is paddy field. Nothing has been brought that it is rocky, only it has not been.
Whether that is
केते इम्पैक्ट हो जे ब्रेन मैटर बाहर
ब्रेन मैटर पैडी ये
ब्रेन मैटर बाहर नहीं है, लैसरेशन ହେଇଛି ब्रेन
बरा नहीं लैसरेशन ହେଇଛି,
that is why the doctor
नहीं सेठी पर से दिया हला इटा से कहले
नहीं डॉक्टर का पास सेठी भी पचराई से कहते without fracture also brain matter
yes that is what, and that is how, but in this case a specific report is there it are ହେଇଛି परा. That has also been brought in the cross examination. ନେଲେ
Cross that even without fracture of the scalp, a laceration of the brain is possible.
no laceration is possible, but other aspects are there. The 3 layers have been lacerated. It's 3 layers of dura, pia, arachnoid matter are lacerated. These 3 layers have been. So what
These
is
layers of the brain have been lacerated without any
what is the
fracture
extent of impact that is required for?
এটি মানে ফ্র্যাকচার কিছু নাই
না
কিন্তু ভিতরର
ব্রেন রে ইনজুরি ହେଇଥିଲା
ব্রেন ର ইনজুরি ହେଇଥିଲା ব্রেন ইজ so impact
a hard impact has been caused. मैं ସେଇଥିଲାଗି 14 ରେ ଡକ୍ଟରଙ୍କୁ ପଚାରିଛି ଆଉ ଡକ୍ଟର କହିଛନ୍ତି it is possible by a fall. Falls resulting in a
were breaking the house of so and so Jodhu Behra তারপরে
disbelief
damage behind fiber লাগিয়ে কটারি গ্লো
लाठी जो भोल भाई तो भगवान बेरा
ଏମାନେ ସବୁ କେତେ ବର୍ଷ ଲେଖା ରହିଛନ୍ତି?
They were in custody throughout the trial. They have been granted bail.
No, just calculate it and tell us that what period if when they are taken into custody and when the judgment was pronounced and then when they were granted bail by this court in the criminal appeal.
Because that's the time, at the time of the rainy season, there is no such hard.
This occurrence, you see, the accused statement was recorded in 97.
Judgment is
And,
also in 97.
at that time, this a appellant number 1 was 26 years. So if you add almost 30 ମାନେ ପାଖାପାଖି ସବୁଗୁଡାକ 60 ପାଖାପାଖି ହେଇଯିବ ବୋଧେ।
ମାନେ
ଆପଣ ଆପିଲରେ ଯୋଉ ଏଜ ଦେଖେଇଛନ୍ତି ହଁ ନାଇଁ ଓବିୟସଲି ସୋ ଯୋଉଟା 60 ଥିଲା ତାର ତ ଡେଥ୍ ହେଇଗଲାଣି ବାକି ଯୋଉଗୁଡାକ if we add at least 28 ଯଦି add କରିବ ଆଦେରେ
ଜଣେ 48 ଗୌରାଙ୍ଗ ପ୍ରଧାନ 48 years at the time of
48 ହେଲେ
98 ରେ 48
ହଁ 28 ପ୍ଲସ୍ କରିଦେବେ ତା ଦେହରେ
70 ଆଉ ଅନ୍ୟମାନେ
76 ବାକି ସବୁ 60 ପାଖାପାଖି ହେଇଗଲେଣି। ଇନସିଡେଣ୍ଟ ହଉଛି 94 ର। ଗୁରୁବାର ରଖିଦଉଛି ଆପଣ ଦେଇଦିଅନ୍ତୁ ଗୋଟେ ଛୋଟ ନୋଟଟେ ଯାହା ସାଇଟେସନ ଦେବା କଥା। ଆଉ କଣ କହିବେ ଯାହା ହିଁ କରିବେ ନୋଟରେ ଦେଇଦେବେ ତାଙ୍କ ସବମିଶନ ତ ଶୁଣିଲେ ଏଇ ପାର୍ଟଟା 3 ଜଣଙ୍କର କନସିଷ୍ଟେଣ୍ଟ ଅଛି ସେ ମେନଲି ଉଠଉଛନ୍ତି ସେ ଯୋଉ ମେଡିକାଲ ଏଭିଡେନ୍ସ discrepancies ରହୁ
they are only the dispute that so far as medical evidence is concerned
ହଁ
not other part
ତାଙ୍କର ଇଏ ହଉଛି ସେଇ ପୁରା କହିଲି ଯୋଉ ଗୋଟେ ଇଞ୍ଜୁରି ନେଇକି ମାଡଟା ନେଇକି କଥା nobody has stated that who has caused it. Other injuries are on the non-vital part of the body. Doctor has stated that cumulative effect, which he has not stated in
that is not the PM report.
PM report not there ଏବଂ ସେ ମାନୁଛି ମଧ୍ୟ ଯେ ମୁଁ PM report ରେ ଲେଖିନି ମଧ୍ୟ in cross examination he admits that yes I have not stated about the cumulative effect. Perhaps public prosecutor has stated to depose like that he has still told. Otherwise बाकी ସବୁ ଜିନିଷ PM report को देखिକି नहीं କହିଛନ୍ତି ए गोटे लाइन डेविएट करिगले PM report ए जो कहिदेलेनी head injury with cumulative matter
with other injuries
associated with cumulative
associated apart from that all the acute PW1 6 and 15 eyewitnesses along with the other witnesses that is PW11 and they are stating that they are saying that they are the group of the person come and
no other witnesses whoever have stated they have stated about the occurrence. We are not on occurrence.
The main
occurrence
field tar jota hai ji tari upru focus karandu bartan se सब गलेनी से जो मेजॉरिटी जो पार्ट टारे मन सम जो ओमिबस टाइप ये सब आक्यूटा लेकिन से ता क्रीम जिंसटा को आनिकनी ट्रायल कोर्ट करिसेंती ए तीनटा को आनिसेंती एति होची तांकर ये तादर गोटा को मते छाडी चंदी जदियो PW15 ता ना को ऐड करतला
the evidence is consistent with regard to Vidyadhar but is good luck to
विद्याधर से तांको रूप ऊपर चढ़ी के भांगी
that is consistent
सेटा कंसिस्टेंट अछि किंतु आउटे से जो आउ जने अक्यूज्ड टू से असॉल्ट रे PW15 तक इंक्लूड करछि मिस्टर पंडा
yes
जोटा की से ताको छाडी चंदी काई ना ए जो दि जण ताको ओमिट करछि
टिकी नायक को
हां 1 ଆଉ 6 ता ना कहि नांती ओनली सेई बोधे 15 केवल तेनु बाकी
benefit of doubt that
बाकी जो गुडा को कंसिस्टेंट रही ताकू बेस करी कि कन्विक्शन टा आइछि जो 7 जन को ताकू बाहर करी आनिछि कोनची ट्रायल कोर्ट सेटा को होछि जे जेहेतु दैट इज consistent in the statement of all the three, ethipai conviction is.
But the charge in the two set charges.
Right. Obviously, see, जो माना main assault, अपन करो ये टा नहीं FIR रे.
ସେଇଥିଲାଗି ତ that is how you have to see when 7 persons assaulted one man. 7 persons assaulted one man having lethal weapon with them. Nature of injuries. What is the nature of injuries resulted out of this assault? Except 9, none of the injuries are fatal. So, in that is how this question arises. Whether this, if in case you fail to assess the nature of injuries 9 to be out of the assault, you have nothing.
ये जो सेटा कहाँ की segregate करी charge frame कले, ना right from the beginning, FIR story they confined the same man of mine. It's not that for the first time asila here. ते charge मध्य है ही सही थी पाएं जो कोना दी जो इतनी लोगों पाएं अलगा कर देले सेटा because right from the beginning same man का ना रोई छी जे यही माने ही तक मारी चंदु धान बिलो को नहीं गले ये कले ये थे धरतला ସେଇଟା ହିଁ ତାଙ୍କର କନସିଷ୍ଟେନ୍ସି ମେଣ୍ଟେନ୍ ଅନ୍ୟମାନଙ୍କ ନାଁରେ ଏଇ 50 ଜଣ ଲୋକ ଆଇଲେ ସେ ଘେରିଲେ ଅମ କଲେ ସମ ଦ୍ୟାଟ୍ସ ଡିଫରେଣ୍ଟ so that is how the specific charge was framed. Mr. Panda, you asked Mr.
Basically, the note is ready to be.
Citation. There are citations. I am sure there are citations. One injury is fatal. Others are on the non-vital part of the. What would be its effect? Yes, Mr. Acharya, you are ready.
Yes, sir.
We'll take up this matter because on that day they will just submit their written note of submission, and we'll start your case on Thursday. Okay.
Thursday.
Yeah.
Thursday that this is
कौन हो ये
Justice
सुधर साहब रहते हैं
आया
सुधर साहब रहता ना
नहीं Justice
ठीक है कल पढ़े हैं
prematurely released and another accused. If that report has come or not, I don't know. The Lordship last date has called for that report.
Has it come?
No.
You answer it tomorrow.
If it has come, then the matter will be heard.
No, we can take it on Thursday. They will bring it. They
already got order passed.
Yes. Yeah, I don't see it in the note of the list.
No, not yet.